Appellate Division, Supreme Court, First Department. D.D. All persons having business with the Appellate Division draw near, give your attendance, and you shall be heard. Will you be seated?
Welcome, folks. Welcome to the Appellate Division. I guess this is like opening day. So hope you're ready. We are. There are 7.5 hours of argument time requested, and I don't think you folks want to be here into the evening. So please ask for the time that you need to convince us of your important points. Don't educate us on your appeal. I assure you we're a hot bench. And one more just note of housekeeping. The red light is for you folks. So when you see the red light, please finish up your thought. Of course, if one of my colleagues has a question, they will continue asking those questions, even if the light is red. First case on the calendar is People versus Batista. 5, 2, and 5. Luna versus Motor Vehicle Corp. You don't have an adversary. Do you wish to submit, sir? Or?
If I could just, since I'm the appellant, if I could have 2 minutes.
You got it. 2 minutes.
Thank you.
V. Michael is submitted. People versus Gray. Submitted. People versus Arthur. Submitted. Haim versus 875 Park Avenue.
Brian Mazzola for the appellants and respectfully request 5 and 2.
5, 2, and 5. Hernandez versus Opera Owners. Well, I hope it's not off when you're driving. I'm sorry, 5 and 2? 5, 2, and 5. People versus Feltmouth is submitted. Enchante Accessories versus Navigators. 5, 2, and 5. The PBA versus NYCCB. My practice is to give 8 to the respondent, same as your adversary, but I'm happy with 6. Is that all you want, a 6?
I'll take 8 if you're
Well, I just want to be... Well, each case is different. 8, 2, and 8. People versus White.
You skip Reed.
Oh, I apologize. Reed versus the city. Judge Rodriguez is excused. Submitted. People versus White. 4, 2, and 4. Smith versus Extel West. 5, 2, and 5. Dubauchi versus the Transit Authority. You scared your adversary away. Thank you very much. Submitted. People versus McFall. Submitted. Oliveira versus Top Shelf. 5, 2, and 5. Kunz versus Hakkinen. 5, 2, and 5. People versus Destiny S.
Appellate request 82, Your Honor. Appellate request 3 minutes. Respondent.
4, 2, and I'll give you 4. Odom versus Williams is submitted, as is the final case, 4CS versus Kahari Diamonds. First case up is People versus Batista.
Step up.
You may proceed, counsel.
Good afternoon, Your Honors. Nathan Brown on behalf of the appellant Armando Batista. It is lovely to see you all again. In People v. Walker, the Court of Appeals warned that police do not have, quote, carte blanche to conduct any search they want and call it an inventory search. But that is exactly what happened here. The facts demonstrate for 3 main reasons that this search was an invalid inventory search. The first was that the search was initiated prior to Mr. Batista's arrest. The second was
So
that
how do you deal with the fact that the motion court made a finding of fact based on credibility that the defendant had been arrested before the search started? I didn't see that you made any appropriate analysis of why we should overturn the motion court's finding of fact, which we normally don't do.
well, the motion court didn't actually state its basis for finding that fact.
But it did make that finding. You still have to address it, and you didn't address, I didn't see anywhere in your briefs where you addressed why we should overturn the motion court's finding of fact.
Well, we certainly presented in our briefs why an arrest did not occur here.
Right, but you didn't address the court's finding and why we should overturn it.
The court
Where has a very particular standard.
The court did not make any factual findings in their decision. They noted that an arrest occurred. They didn't identify any of the grounds for which that arrest was supported. They stated that an arrest occurred. Under the circumstances here, an arrest requires particular facts to demonstrate that during a traffic stop that a de facto arrest occurred. And the court's decision, although it does find that arrest occurred, did not state any fact that supported that finding. If Your Honors saw one, I certainly missed it, but the decision that I had stated simply that he was under arrest. It did not.
And I don't think the court has to say why it reached that conclusion. It's your obligation to say that there was nothing in the record to support that, and I didn't see that you did that at all.
Under these circumstances, we certainly demonstrated why under these facts that an arrest did not occur. I can go through them. What occurred here factually was nothing more than a routine traffic stop, what the U.S. Supreme Court and the Court of Appeals here have described as a de minimis intrusion, typical of a routine traffic stop until the trunk was searched.
And how was that issue preserved at the motion court level? I didn't see anywhere where your colleague below raised that issue that the arrest had not been made before the search began. Can you point me to anywhere in the record?
Absolutely.
In the motion court where defense counsel made that argument?
Well, first of all, our position is that the timing of the arrest.
I'd like you to tell me where that argument was made in the motion court.
Okay, so you can look at the DA's opposition at 4. You can look at the people's decision itself. I can get you the brief below for defense counsel stated. I don't have that in my notes, but they stated that, and this is what I was trying to say before, Your Honor, that it's not a separate fact. It is part of the valid inventory search procedure, and so defense counsel below raised it with enough specificity that the prosecution opposed it with equal specificity, again, at their opposition at 4, and that where they stated regarding the timing of the arrest, quote, at this point, defendant was under arrest based on the warrant, and the court reached it in their decision. In Court of Appeals, People v. Prado, they held that preservation is sufficient where a general objection is made and the court reaches a decision. So our position is this is squarely preserved based on the motion papers as well as the court's decision in Court of Appeals precedent.
Well, even if you're correct on that, how do you get around the waiver here?
The appeal waiver is I would consider exceptionally terse. It gave the misleading impression that it was a complete bar to appellate review, which was only available had Mr. Batista taken his case to trial. the appeal waiver itself, which I can read here in my brief time, it's so short, your right to
Counsel,
appeal.
is the appeal waiver outside of waivers that this court has found to be valid in the past?
Has this court found one similar to
Yes.
this? I'm not entirely sure. I would imagine no, because this is an incredibly terse and misleading appeal waiver. It does not advise of any specific rights that are being waived, any rights that are retained about appellate counsel. In fact, my adversary relies heavily on the written waiver to cure the insufficiency of this particular oral colloquy. Now, of course, the written waiver is itself problematic because the record does not contain any demonstration that the written waiver was explained to my client, that he understood it. It is raised at the initial inception of the hearing where the judge directed defense counsel to explain it, and is never mentioned once again until she confirms that my client signed it. Not that he understood it, not that it was explained to him, but only that he signed it.
Thank you, counsel.
Thank you.
You may proceed.
Good afternoon, Your Honors. Jacob Marcus for the people. I'm going to pick up right where defense counsel left off regarding the waiver. It's not true that the court only asked, did you sign it? They said, I see that you've executed a waiver. Did you understand it? Did you sign it? So this was, I think, clearly in reference to the written waiver, which this court and the Court of Appeals has held is sufficient to show that the waiver was knowingly, intelligently, and voluntarily made. Moving on to the merits of the issue, I want to again pick up with the hearing court's finding of fact that defendant was under arrest. Defendant now complains that that was perhaps a terse finding, and I think the reason for that is because this was an unpreserved issue. Down below, everyone seems to be in agreement that that defendant was arrested. Now, in defendant's motion papers, they only raised 3 arguments. They said that there was no warrant for his arrest, that the stop was invalid, and that the officers didn't follow proper inventory search procedures. They never argued that defendant wasn't under arrest, and to get the controlling question more accurate, that the vehicle was unlawfully impounded. Defendant doesn't have to be under arrest for a vehicle to be lawfully impounded. It would suffice that defendant was the only person on the scene and that he didn't have a valid license. Now, the record, which of course isn't sufficiently built out because of the preservation issue, does suggest that that was exactly the case. Defendant had 2 open warrants for VTL 509, which is unlicensed operation. He had also, within the year prior, or within, I think, 18 months prior, been convicted of aggravated unlicensed operation in the 3rd degree, which shows that his license had been revoked or suspended and he knew it. Those were convictions, open warrants. I think that that alone, had the people been alerted to this particular complaint, that the car wasn't lawfully impounded, would have prompted us to build a record and show that defendant didn't need to be under arrest. However, as we note extensively in our brief, the hearing court's finding of fact was justified by the record, by this court and the Court of Appeals jurisprudence on when a de facto arrest occurred. Because the impoundment of the vehicle was lawful, the officers were entitled to conduct an inventory search, and then I think they followed the inventory search procedures as set out by the NYPD patrol guide, which the Court of Appeals has affirmed as constitutionally valid step by step.
Counsel, the fact that the court sort of reopened the hearing to allow the people to submit the arrest warrants into evidence, does that have any bearing on your argument or support your argument in any way regarding the preservation of the arrest?
I think it doesn't impact the preservation issue. The reason the people introduced the warrants was because defendant had argued in his motion papers that there was no warrant for his arrest. They said the people didn't introduce it, and we reopened to bring it in. I do think it impacts the question of whether an arrest was even required, because I think the warrants show that defendant probably, had this issue been raised, probably wasn't licensed to drive that vehicle away from the traffic stop.
Was your position that the defendant was arrested or not at the time that the search was conducted?
At the time the search commenced, defendant was under arrest.
And what are the indicators to show that a reasonable person would conclude that under those circumstances, they were not free to leave?
I think that having your car stopped, having 3 officers approach on either side, removing you from the vehicle, frisking you, and then placing you in the back of a patrol car with an NYPD sergeant, while you have 2 open...
I'm confused about that issue, because it seems to me, at least from a look at the transcript, it appears that he was in his own car in the backseat. Can you clarify that?
Yeah, so The way I read the transcript, this is Flores' testimony on page 76. He says, defendant was patted down, and then afterwards he was, I'm quoting, escorted to the back of the vehicle where he sat with me in the back of the vehicle. I think in context of that record, he's clearly talking about the patrol car.
Because the police officer wouldn't sit in the back of his vehicle with him, right? It would
Exactly.
generally be that the police officer would want to be in their own vehicle. Is that why you think that he was sitting in the back of the police vehicle?
Both that fact and the fact that he then testifies that they searched defendant's car, including the back seat. So I don't think it would make sense for him to be in the back of defendant's car, climb in for some reason, and have them searching around them. And then as to the timing,
Would you say that, because the record is a little murky on that issue, if you were on the back of his own car, would a reasonable person under the circumstances believe, even if a cop's next to him, that he's under arrest?
I think that that's certainly a closer call. I'm not prepared to say that a reasonable person wouldn't have felt that they were under arrest. I think People v. Boodle at the Court of Appeals has a similar, and in that they're in the back of a patrol car, but I think being told to sit still with your hands where officers can see them would lead a reasonable person to think that they're not free. The standard is, of course, whether you felt detained by words and acts, and I think here they would have. So defendant's claims are waived, unpreserved, and we ask that you affirm. Thank you.
Counsel.
I just wanted to note two things. One is that, as Your Honor's pointed out, the testimony around where my client was when he was removed from the car is unclear. My adversary points only to the most helpful testimony when another officer testified the exact opposite of Sergeant Flores. Officer Tavares, who is the one who actually patted down my client, testified that he was standing right next to his own car and allowed back into the driver's seat. I'll also note that he was never, the record doesn't
More
say.
importantly, can you respond to the preservation arguments that or lack of preservation that your adversary just made?
I placed our preservation arguments, I think, on the opening argument. I don't, again, I'll reiterate that the fact of the timing of my client's arrest is not a separate fact than it is a part of the argument that was raised with specificity by defense counsel below, such that the DA responded to it.
Don't you think that your adversary then could have raised, for example, the issue with respect to the fact that your guy had a suspended license, no right to drive the vehicle, et cetera, et cetera. All that was never really raised because maybe it wasn't clear as to what you were arguing.
I can only say that it was raised with enough specificity that the prosecution responded to it with specificity themselves, and that that should suffice for preservation. The Court of Appeals does not require has warned against a hyper-technical reading of preservation and has noted that it only needs to provide the prosecution an opportunity to respond, which they explicitly did here. I don't see how this particular set of circumstances renders it unpreserved, and I'll also note that the Court of Appeals has explained that the fact that a fact is emphasized with more vigor on appeal does not make the issue unpreserved because it wasn't stressed with that same vigor below. I also just want to reach the appeal waiver because I think that my adversary misconstrues what occurs with relation to the written waiver. What I read for your honors before is the oral colloquy. What immediately follows from that, and what is in the court reporter's transcription as being a part of the same oral colloquy, is, do you understand the waiver of appeal? It is not a separate, it's not moving on. It's a part of the same oral colloquy. And then oral colloquy, and then subsequently says, have you signed it? Then moving on. There's nothing in the colloquy itself that indicates that she is pointing to the written waiver when she moves on and starts saying, do you understand? That is a reading into the exchange.
Thank you, counsel. Thank you both. Luna. You may proceed, counsel.
Good afternoon, Your Honors. May it please the court. My name is Jack Lockwood. I'm an attorney with Pollock, Isaac, and DeSico, appellate counsel to Bogaraz Law Group, attorney for the petitioner appellant. The Supreme Court here erred in denying the petitioner's motion for leave to bring an action against the Motor Vehicle Accident and Indemnification Corporation. The court erred in finding that the petitioner failed to demonstrate that there was physical contact between the bicycle and the hit-and-run vehicle.
What do you make of the respondent's argument that there should be a framed issue hearing?
Your Honor, the respondents have conceded that the court erred in considering the pre-hospital operative report or the pre-hospital care report. They say that there should be a framed issue hearing on this issue. The pre-hospital care report is not admissible, so it wouldn't be admissible at a framed issue hearing. There's two levels of hearsay here. There's the fact that it's a document, so you need to get it in under the business record exception. So
Are you saying that on this record, there are no issues of fact requiring a framed issue hearing?
That's correct, Your Honor.
Thank you, counsel.
Thank you.
People versus, Haim versus 875 Park Avenue. Please proceed, counsel.
May it please the court, my name is Brian Mazzola, and I represent the appellants. Your Honors, we have here a decision that was issued that simply has no reasoning in it and states that the parties should engage in discovery. But there's a number of reasons why discovery is not appropriate in this case. First and foremost, res judicata applies, and quite frankly, I have not seen a more compelling case for res judicata, where we have the same apartment, which is apartment 9B within the co-op, the same issue, which is a dispute over the number of shares allocated to that apartment, the same arguments in that the Abrams case, which was the case that occurred in 1991, was decided in 1991, had the same argument saying that there was an over-allocation of shares, and Ms. Abrams had argued also that the tax deductibility of the maintenance payments was at issue. So all of the factors that were in this case are in this case.
Is there an issue of privity here between the tenants and the prior tenants, the Abrams?
No, there is no issue of privity. The respondent has argued, and I think tries to imply that there's a different property interest here. But that's misleading. There's a reference to apartment 9AB that Ms. Hyam owns. Ms. Hyam and her husband purchased 9A in 1995, I believe. 10 years later, after knowing the outlay of this building, knowing the apartments on each floor, she argues that there's a different size and different outlay, and that floor 9, where her apartments are located, has 3 apartments, whereas the other apartments have 2. She undoubtedly knew that when she purchased 9B, completely independent and completely separate. So
When did she purchase 9B?
in 2005.
And that's the claim that 9B has a misallocation of shares, right?
Yeah.
So if the purchase of misallocated shares happened in 2005, normally the statute would run in 2011, right?
Yes, I say best case scenario.
Best case. Okay, let's assume, right?
Yes.
So now here we are in 2020-something, and so it's 10 years too late.
Well, I say it's nearly 80 years too late.
All right.
The initial share allocation occurred in 1947 by a non-party, the sponsor. And the plaintiff argues that the statute of limitations has not run because each year the co-op has an obligation to re-examine.
As to her?
Well, the implication is it would be that the co-op.
Is there anything in the bylaws that requires that?
Actually, the bylaws dictate that the plaintiff owns the shares that she purchased and that the shares cannot be reduced or reallocated.
Is there anything that says every year I have to the corporation has to re-examine as to the shareholders the share allocation?
No.
So there's no contractual obligation, right?
No.
There's no tort obligation, correct? Okay.
How about a continuing wrong?
Well, if there is no continuing wrong, first of all, because she purchased the shares and she's obligated to own those shares, and so if there was what we have here, if the respondent's arguments are bought and accepted, that would mean effectively you would upend the stability of this co-op, and that the co-op would have an obligation every year to look at everybody's apartment, measure those apartments, look to see if any factors have changed. And nobody here knows, you know, the judge said, Justice Adams said, do discovery. Nobody here can say why the shares were allocated to 9B, you know, as they were allocated. It could be the size, it could be the location, it could be any number of factors. And one of the things that the respondent relies heavily upon is a report that was annexed to the complaint from Orsid. And in that report, Orsid, there's a conclusion that says this can only be unreasonable. Well, if you look deeper in that report, the author indicates in a note he has no understanding of why or how the sponsor allocated the shares. He states that it was difficult to determine any facts associated with this issue. Moreover, there's an indication that the person who authored the offering plan, Mr. Ives, was the godfather of co-ops, and that he is the person who essentially laid the groundwork for the cooperative. He was a groundbreaker, I think is what the reference is. And so Mr. Ives in the report states that there's a fair apportionment of stock. So, yeah, you know, on that report, we know that there was a fair apportionment of stock by the godfather himself of the cooperatives in New York City. So,
If we decided for the shareholder, wouldn't it also mean that somebody purchasing shares would have no obligation to do any due diligence to determine whether or not the allocation of shares was fair and could challenge it at any time?
I think that a person who's looking to purchase has an obligation to do due diligence. In this case, Ms. Hyam purchased 4 or 5 years after the Abrams decision came down. And again, as I noted, she had lived in a co-op for 10 years, knew the outlay, or should have known the outlay, and had the availability to review the documents associated with this apartment.
Thank you, counsel.
Thank you.
Good afternoon. Michael Fishman from Phillips Nizer on behalf of the respondent, Graciela Heim. Listening to counsel, it strikes me that we've been told what Mrs. Heim must have known about the apartment, what records there may exist as to how the shares were allocated back 80 years ago. That is exactly what the court below wanted to have happen.
But wouldn't she have had access to the initial offering plan, which would show what shares were allocated when she bought the apartment?
But there was no way for her to know from that how the misallocation of shares within the building would have occurred.
Well, she could have looked at all she could have looked at what shares were allocated to all the other apartments at that time.
Well, but
That
there's still-
information
there's
was
still-
available to her, wasn't it?
I do not know, and nor is that in the record.
In the ordinary
counsel-
course of things, isn't that information
ordinary
that's
course of
available to a
things.
purchaser?
Yes, Your Honor. What is missing in this analysis, however, is the obligation on the part of the cooperative in order to become a cooperative housing corporation. It must meet certain standards. The shares allocated to each apartment.
Counsel, what about the previous decision from 1991 that discusses this very issue that we're here talking about?
Well, the Abrams decision involved the request to reform the leases for the co-op, for 9B. We're not seeking to have that happen. I appreciate the fact that you cannot go back.
But you can't look at that. That's so narrow to say that. The issue in that case was whether or not the shares were misallocated, correct?
Correct.
And that's exactly the issue that you're raising in this case, that the shares were misallocated, correct?
That is correct.
So how is it that you get to litigate that again?
Because the obligation is on the board, is on the co-op. If there was a document that showed us how.
What has that got to do with whether or not the issue was resolved?
Because, well, the issue was not resolved. The court determined below that they could not reform. They never.
One second. Did the issue of whether the shares were misallocated, you're saying was never resolved in that 19?
That was not the decision that the Abrams court came down on. The issue was argued, it was not decided.
Okay, all right. So your party takes from that party, so there's privity, and now you are, under res judicata, you are prevented from arguing anything in sort of massaging the claim to reach the same issue, right?
No, because the issue under res judicata, you need to have that same issue actually decided.
I don't think that's accurate. It's issues that were raised.
Yeah, or could have been raised.
That's,
But that would have been
that's-
collateral estoppel, right?
We're
That's,
talking about res judicata. Res judicata applies to both categories.
Right.
Issues that were raised or could have been raised. Even if you're right, couldn't this issue have been raised back in the Abrams action in 1991?
could it have been raised? Yes, it could have been raised.
Well, then, that's res judicata,
But that
right?
doesn't stop the allocation issue and the obligation on the board. If there was a document in the files of the co-op that explained why this was allocated the way it was, my client has 35% more shares allocated to her.
And she knew in 2005 when she bought the shares, right? That was the state of
We
affairs.
don't have anything in the record that would indicate.
Well, okay.
Which is why we need discovery.
She bought the shares, she knows, or she had at least an obligation for reasonable inquiry in 2005 when she bought the shares as to what everybody had, correct?
Yes, Your Honor.
All right, so.
But under Biamonte.
At 2005, she knows what everybody's got. She had the ability to determine whether or not she had a claim for misallocation. She doesn't sue for many, way past the statute of limitations years later. How do you get around that?
Because, well, I get around that, Your Honor, by virtue of the fact that the co-op, the board of the co-op, has a continuing obligation under the Internal Revenue rulings to
No, but
determine
that's
this
to
each
the
year.
IRS. That has nothing to do with your client. The plaintiff has, the co-op has no obligation to your client to show me where in the board minutes or any, she is a person who purchased. She is a shareholder of your corporation. The only place she gets rights from is through the shareholder agreement. So show me where in there she has any rights more than what, at 2005, a 6-year statute of limitations.
Well, because each year they have a continuing obligation. They have
So are you arguing continuing wrong? Is that what you're saying? There's a continuing wrong here?
it is not a continuing wrong as in the Green case, more like Bulova, which is cited within that case, where every year there's an obligation. They send out a notice to the shareholders. Here's what your deductibility is as a member of this cooperative housing corporation.
Where does that obligation come from? It comes from a 2005 purchase. It's not like every year she's purchasing shares. So in 2005, she knew that that was what was going on. So it isn't, to me, it seems like you can't, the fact is you're arguing she still has damages, but that's different from it's a new and continuing wrong, right?
But we're seeking a declaration that they are not in compliance with Section 216. Whatever happens after that, whether they become an S-corp because they're not entitled to the benefits of Section 216, doesn't mean that they can say, well, it must somehow be a reasonable relationship because somewhere in a document we don't know where it is or don't know what it says, something happened. And so at some point, they have to hire an appraiser. They have to hire somebody to come in and make a professional obligation or a professional observation and report, as we did, as to whether these are reasonable relation to the shares that are.
Thank you, counsel.
Thank you.
Counsel, let me ask you, what do you say to that argument that somehow an IRS regulation creates a continuing wrong sort of theory of damages against your client?
Well, there's two things I say. The first is there's no private cause of action under the IRS code. That's for the IRS to enforce.
So the plaintiff has no rights under that code,
The-
right?
the plaintiff
So
has
can't sue based on that, okay?
That's right. And then the second point that I have to say to that is she has no damages. Her argument is that I might lose my tax deductibility status, and ironically, what she is asking is for the court to destroy the tax deductibility status. She wants to blow the co-op up.
Well, you can't, people do what they're going to do, right? Whether it's in their best interest or not.
Exactly. And so that's my response to that. And I think we've gone over everything. And unless there's any questions, I will rest on the submissions.
Thank you, counsel. Thank you both.
Thank you.
Hernandez versus Opera Owners. Anytime you're ready, counsel.
May it please the court, my name is James LaFreeze. I'm from the law firm of Black, Margie, and Sanford. We represent third-party defendants, Appellant, Poltech in this case. We are here today because the lower court failed to compel respondents, Opera and Halstead, to abide by a binding arbitration agreement within a contract they claim to be third-party beneficiaries to, forcing us to do today what we shouldn't be doing, litigating in court. The basic premise of the appeal is rather simple. My client was performing a renovation project for the unit owners, the condo unit owners in this case, who are not involved in the appeal, Weinstein and Jing. And there was a contract, which I'll refer to for purposes of oral argument as the Poltech contract, that my client entered into with the unit owners. That contract incorporated by reference something called an alteration, which was what the respondents entered into separately and prior to that time with the condo unit owners. The Poltech contract contains a clear mandatory arbitration provision in Article 21, and it covers all claims, disputes, and other matters arising or related to the contract. That's a broadly worded mandatory arbitration provision. Opera, the owner of the condo building, and Halstead, its managing agent, commenced a third-party action against my client for, among other things, contractual indemnification and breach of contract for failure to procure insurance. In other words, seeking relief from the very contract that they claim to be third-party beneficiaries to. We have demanded arbitration. They've refused. The law is clear that although they are non-signatories to our contract, the Poltech contract, they certainly, through the theory of the direct benefits theory of estoppel, are bound by the binding arbitration provision.
Isn't the essence of this is that they claim to be third-party beneficiaries of that contract, but they don't want to be bound by the provisions of that contract that they don't like, that is, the provision requiring ADR?
Which is exactly what the courts say they shouldn't be permitted to do.
So they sort of want to have it both ways.
They do. They are trying to select and pick which provisions of the contract that suits their purposes, disclaiming part of the contract while alleging a breach of the rest of the contract. And that's something that actually the Court of Appeals brought up in God's Battalion versus Melee, 6 NY 3rd 371. Based on the contractual provisions in the Poltech contract, simply put, Opera and Halstein have to submit to non-binding arbitration. The claims against my client for indemnification and breach of contract are defensible in our opinion, but they're not the subject of this appeal. Those issues should be determined by an arbitrator, not by the courts. Parenthetically, there was also a claim for common law contribution and indemnification. We submitted as part of our appeal that those claims are dismissible as a matter of law because we're the employer and there's
Is there any
no
allegation of grave injury, counsel?
There is not, Judge, in none of the pleadings.
Was
and
there
it
any
wasn't
argument
posed by
against that? Yeah, that's what I'm saying. Was there any argument against that?
I apologize.
Was there any argument on appeal that it was a grave injury?
Opera Halstead submitted no opposition
Okay.
to that, Judge. If there are no further questions at this time, I'll...
Thank you, counsel.
Thank you.
Good afternoon. My name is Thomas Tordone. I represent the respondent Opera owners. It's our position, addressing this appeal by the issues raised by the motion below. First, the motion to dismiss was pursuant to 3211A7, failure to state a cause of action. As a matter of pleading, this third-party complaint pleads a valid claim for contractual indemnification. Paragraphs 26, 27, 28 of the third-party complaint.
What's the basis for contractual indemnification here?
The alteration agreement that was incorporated by reference.
Based on a third-party beneficiary, correct?
No, forget about the third party, but I say the third-party beneficiary is misleading. It's alleged in the third-party
Are you
complaint.
alleging that you're a third-party beneficiary of
It's
the
alleged,
contract?
but I maintain that it's not needed. The key here, Your Honor, is that the alteration agreement is incorporated by reference and assumed by Poltech. That's the contract in which they seek indemnification, not the Poltech contract. It's right in the third-party complaint, including the indemnification clause, that Poltech assumed an obligation to indemnify Opera House from any claims asserted against.
Is Poltech, did you allege that Poltech was a signatory to the alteration agreement?
No, we allege that the contract was incorporated by reference.
Yeah, but okay, and in that it says, but it doesn't create any third-party beneficiary.
No, I see it's a superfluous allegation in a third-party complaint that Opera House is a third-party beneficiary of Poltech. They don't need to be a third-party beneficiary.
It is asserted in your complaint.
It is.
You're saying it was, so we shouldn't look at it because it was excessive, it was
not necessary.
surplusage?
Right, the surplus.
So you're not bound by it even after you've alleged it?
I don't
Why
think
shouldn't
we're
you be
bound by it.
bound by it if you alleged it? If you
Because we
allege
are.
you're a third-party beneficiary of the contract, doesn't that connect you to every part of the contract?
No, what connects us to it is the incorporation of the alteration agreement into the
I'm sorry.
Poltech agreement.
You're claiming third-party.
assumed it.
In your third-party complaint, you claim that you're a third-party beneficiary.
Yes.
And now you're saying we should disregard the allegation that you made?
Yes,
What about judicial estoppel? Why aren't you bound by the allegation that you made?
because it's a motion to dismiss under 3211A7. And if you assume the facts alleged in the complaint and you give us the benefit of the doubt, and then for every favorable inference that can be drawn, the claim here is that the alteration agreement controls and not the Poltech agreement, and that's what should guide the court in this decision.
So we should now say that some things that you said you're bound by and other things that you said you're not bound by?
That's right. For purposes of this pleading.
I've
And I
never
think
seen
that's
an
the
argument like
position that Judge Guzman took below, because it's premature at this point to sort out what they're arguing. Additionally, they're.
Okay, if you're saying that you are the third-party beneficiary of the Poltech contract, right?
We're saying that.
And then that contract requires arbitration. And you're also saying, but other agreements were also incorporated. But if you can't say, if you're saying that you are a third-party beneficiary of the Poltech contract, regardless of how many other agreements are incorporated into it, you're bound by the arbitration clause.
No, I don't think so, because.
How do you get out of it?
Because we didn't sign the Poltech contract. And the
You
Court
didn't
of Appeals
sign any of those contracts.
The alteration agreement we did.
Okay,
the
but
managing agent
Poltech didn't sign the alteration
Oh, they
agreement.
agreed to assume it. That's the case.
This
They
is
agreed
my
to assume
point.
it.
You can't, if it's all in that contract,
It's,
then the arbitration provision is all in too, and you're bound by that too.
if we omitted the allegations of being a third-party beneficiary, we'd still have a right to contractual indemnification.
But that's not what you did. And you
Well, we
made
did
the
both.
allegation, excuse me, you made the allegation that you were a third-party beneficiary, and you're bound by that. You can't just say, oh, that was a mistake, sorry.
They allege both, Your Honor, I think. You look at the.
And how can, what doctrine allows you to choose which of the allegations that you made are, that you should now be bound by?
It's alternative pleading. You can always plead, alternative cause of action, some of which don't fly. In terms of documentary evidence, their proof doesn't conclusively establish.
So we have about 20 seconds left. Do you want to address common law
Finally,
indemnity?
even if you disagree with the lower court on this score, the judge was right, I believe, on the intertwined issue, Young versus Jaffe, that when you have this situation where the issues raised by the main complaint, the third-party complaint, are intertwined under Young against Jaffe, these issues should be resolved in a single forum and not piecemeal in arbitration.
Thank you, counsel.
Thank you.
Two quick points. The contract documents that comprise the agreement, which includes the alteration agreement, are complementary. Section 7.1 of the Poltech agreement. And what is required by one is required by all. And that is clear, and the allegations in this case are not only that they're relying just on the alteration agreement. The third-party complaint itself states they're relying on both contracts, which they claim entitles them to relief, which we disagree with, but that's what the allegations are. Indeed.
Well, let's do what your adversary asked to do is to ignore the third-party beneficiary allegations. Is there sufficient basis then to hold your client in under the alteration agreement?
Well, the contract that, the portion of the contract that incorporates the alteration agreement specifically refers to the alteration agreement and says that the contractor, Poltech, shall be bound by those portions of the alteration agreement which apply to it. The indemnification provision within the alteration agreement that counsel is relying on speaks only to Weinstein and Jing indemnifying them and no one else. But again, that's a dispute that we feel the arbitrator should be making in this case. As far as the inextricably intertwined argument, Your Honor, this is a garden variety third-party claim for contractual indemnification stemming from a construction-related accident. If we are to hold that this claim is inextricably intertwined from the main action, then we must assume that every single labor law claim is inextricably intertwined with the third-party actions that they spawn, and that's simply not the facts here. The claims against Poltech rise and fall based on the wording of the contracts, and it can live and die independently of whether plaintiff is successful or not in establishing their main claims against Opera and Halstead.
Thank you, counsel. Thank you both. Enchante Accessories versus Navigators Insurance. Counsel.
You ready?
You may proceed.
David Gauntlet for Appellate Enchante. The key dispute here is resolved by careful parsing of the atypical voluntary payments provision Navigators issued to Enchante. Judge Billings first questioned the Navigators, asking why it applied here to insureds. What led to the response that it did apply, except that there was an issue as to coverage, and that any damages incurred prior to the consent shall not be covered hereunder, was in fact not met because, frankly, opposing counsel skipped the portion about any damages.
Well, but how about just going for the, was there a voluntary payment of legal fees made here pre-tender?
Were the fees made voluntarily by the insured?
I'm just looking at what the language says. It says voluntary payments, A, voluntarily make a payment, comma, assume an obligation, or incur expense or damage. So
For damages. This is all about for damages.
well, but why not just a voluntary payment? Were the legal fees voluntarily paid?
That's not the test. The test is all the language has to be met in the voluntary payments provision for it to be enforceable, because it's a limitation on coverage narrowly construed against the insurer. And so it has to be one for damages. Elsewhere, they have a provision that talks about a particular kind of defense fee. And they say, oh, these are excluded in another portion of this very convoluted and long voluntary payments provision. But where they say that, they don't mention defense fees. And so a fair, reasonable reading, at least one.
Wait. This is what it says. Voluntarily make any payment, assume any obligation, or incur any expense for damages, loss, product recall.
Those are not attorney's fees.
That has uniformly been construed to include any expense, attorney's fees.
Not so, Your Honor.
Well, I guess you and I can disagree.
We can disagree, but if you read Smart
I
Style.
think it's pretty straightforward. It's pretty broad. And I think many courts have decided that includes attorney. Any
language
costs.
is unusual in this context because it's not typical. Smart Style is one that doesn't have that language. They rely on Smart Style as if it's a true limitation, but it isn't because it has different language. When they wanted to tell you that they wanted to deal with attorney's fees, elsewhere in the provision that is cited by the court's decision, they talk about a particular kind of defense fees for a particular distinct kind of activity. So they should have put it there. If you look at our reply brief, we go at length to explain why for damages, one interpretation could be something a little broader, but the appropriate and narrow one includes one that doesn't include attorney's fees. So long as any definition exists, that's a reasonable definition.
Let's assume, counsel, for the moment, you're correct. Even putting aside the issue of the voluntary payment provision, can an insurer be required to pay defense costs without their consent and what's done pre-tender under our case law?
Yes, and the reason is because if you look at what the Smart Style case looked at, it failed to understand that the key issue in New York, along with 5 other jurisdictions, is the filing of the lawsuit. That's the determinative point.
Wait a second. Smart Style said only after tender, right? Do we agree on that? You get costs after tender.
Absolutely not. Look at footnote 3, and explains that that's inconsistent with the rule that it's the complaint that's the...
Oh, I'm sorry. After notice to the insurance agent. Okay, you can pick words with me, but that's the thing.
Yeah, but it's
right?
not, that's not, that provision...
So you're saying Smart Style is wrong?
Yeah, but I'm saying Smart Style was pre-statutory.
I'm just asking you how you feel. I mean, that's what the holding was. And if we follow it, we go from date of notice, right?
Different provision in Smart Style we do not have, that is narrower, where counsel assumed that control of the defense vested with the insurer, which is not true here because they conceded we had a right to independent counsel. So it's no harm, no foul.
What statute are you relying on that you say has changed the law?
The one in New York that dealt with prejudice, Your Honor, that was
3420?
Decided in 2019, and that's the statute that is the one that has been discussed at length in the briefing. And
You're talking about the notice statute.
3420.
Yeah, right.
3420.
That's right.
But I look at 3420 and it talks about injury to person. Isn't this concerning personal injury actions?
No.
Wrongful death actions?
It has been applied to personal and advertising injury coverage cases, and we cited 3 cases from various courts in New York that agreed it applied in that context. And they haven't said anything to the contrary in their arguments. So the problem here is the reason that pretender fees were not available in Smart Style is that the court presumed that they controlled the right to counsel. We don't have that issue because the counsel who argued it was not a covered attorney, didn't raise the issue. They relied on cases that were inconsistent with New York out of California and Rhode Island that presumed that the control would vest with the insurer. And so if you look at the different language, the different facts, and the unique aspect of this policy, a different result attends, and Smart Style does not control. It's pre-statutory, and if you look very carefully at a reply brief, you'll see a lot of reasons why it shouldn't apply here. And this is really an issue of first impression under this policy before this court. There are no floodgate issues because it's a very unique policy with a very distinct voluntary payments provision, and a decision regarding it doesn't need to reach broader issues. It's just a matter of this language was not properly applied by the courts because they misrepresented in oral argument to the court what it said.
Thank you, counsel.
Good afternoon, Your Honors. Jonathan Fryman for Navigators. This court can and should affirm the decision below on one or both of 2 independent grounds. One is that pre-tender defense fees are not recoverable under New York law under this court's precedents. We don't even need to go to Smart Style.
Does 3420 change that analysis?
No, it doesn't change the analysis. First of all, Your Honor, in response...
Well, do you concede that it applies in this case or not?
No, it doesn't apply in this case.
Why?
3420A5 is about notice provisions. It's not about voluntary payment provisions. The Court of Appeals decision in Vigilant, which we cited in our briefs, says voluntary payment provisions are enforceable, clearly enforceable under New York law. A voluntary payment provision is helping define the scope of coverage. It's saying the duty to defend doesn't begin before you even tell us there's something to defend. The duty to defend begins after you tell us that there's something to defend. But that's with regard to the provision itself. Even separate and apart from the provision, you have this court's case law, which weren't dealing with voluntary payment provisions. They were just dealing with the basic principles of New York contract law. That's Bovis, that's Liberty Insurance. In both of those cases, neither of which even addresses a voluntary payment provision. They say pre-tender defense costs are not recoverable. And they're not recoverable for good reason. There's an incentive that the policyholder has just not to tender the defense at all. Just hold on to it. You hold on to it, and then you incur fees as you like. You hire Hughes, Hubbard, and Reed at $1,000 an hour, instead of, as the insurance policy says, counsel who get the kind of rates that insurance policies pay for this kind of matter in this kind of place. So you have an incentive to play foul. Which is what they did here. They waited half a year, they ran up $500,000 in fees, and then at that point, the tender gets turned in. So there's a good reason.
Turning to the provision here, your adversary says essentially that expenses for damages don't include attorney's fees. I mean, there's some argument to be made there. What in this provision do you rely on to say that it includes pre-tender payment of attorney's fees?
Well, the first thing I would, so if we're setting aside the common law contractual interpretation of Bovis and Liberty Insurance, which I contend are stare decisis for this court, but if we set those aside and we go to the question of the voluntary payment provision, which is I think secondary here, but if we go to that, this is simple. I mean, as your colleague noted before, this is very broad language. Assume any obligation or incur any expense for damages. Okay, what are they turning to in terms of why there is any coverage at all here? It's the advertising and personal injury provision, which provides coverage if they're sued for damages. So of course, this is incurring an expense for damages. The entire purpose of the insuring agreement, the advertising and personal injury provision, the entire purpose of it is to provide them a defense for damages and to pay, if necessary, liability, settlement, whatever it may be, for damages. So this is incurring an expense for damages. Go to the basic principles of New York insurance law. What would a reasonable business person think if they looked at something that said incur any expense for damages, and there was a voluntary payment provision that said, you're not going to get paid if you incur an expense for damages before you tender this to the insurance company? They would understand, oh, I shouldn't spend $500,000. I shouldn't spend voluntarily $500,000 because that's an expense for damages. That's to protect me from damages.
Counsel, how do you handle your adversary's argument that, in fact, independent counsel was approved and indicated?
Your Honor, the independent counsel notion is a complete red herring here, and I think irrelevant to the analysis. Whether or not they have independent counsel, there are still rights that the insurer has under the policy. And the right to, and I can turn you to that precise provision, it's page 255 of the record, paragraph 15, independent counsel. One of the things that it lets the insurer do is control defense costs. Just because they have
Counsel,
independent
let me ask you, I'm sorry, I didn't mean to interrupt.
Of course, Your Honor.
I just want to get one quick question in. The first notice that the insured gave didn't include pre-tender costs, right?
When they finally sent us the tender included only invoices that had post-tender stuff in it. Now, some of those were mixed with some pre-tender expenses because, that's the way the billing period went.
And then you
but
negotiated it out.
None of them were just for pre-tender expenses.
So it's sort of some indication that everyone knew what
Everyone knew what was going on. And of course, we were shocked. The first time we heard that there was any claim for pre-tender expenses was when they filed their improper motion for summary judgment in lieu of a complaint and then ultimately filed the complaint. I don't know if my time is up, but I think I've made my points. This court's law is clear, both under the common law and under the voluntary payment provision, and this court can and should affirm on either or both of those bases. Thank you, Your Honors.
Thank you.
When we asked for a defense, we clarified why there was a defense. We didn't ask for particular money. We later provided invoices. They don't argue waiver. They don't argue estoppel. This is no harm, no foul. Go to Southern California Edison 2015. It's very clear about the nature of the trigger of the defense, which is the filing of the complaint, unique among 6 jurisdictions nationally. We always had a right to independent counsel. Since 2006, under the Kniff case, if you reserve rights that could affect your entitlement, you have independent counsel. We had a right to control the defense, no harm, no foul. We just got to it a little later. They agreed we were entitled to a defense. They would have always owned it. They're going to get a windfall if we don't get the recoupment for the defense fees we incurred after the filing of the complaint. There is no case to the contrary. Bovis, read it carefully. It cites to Smart Style. Smart Style cites to footnote 3. Footnote 3 explains what I just stated.
Thank you, counsel. PBA.
May it please the court, Matthew Daly for the Police Benevolent Association. Body-worn camera errors are not in CCRB's jurisdiction. The charter limits that jurisdiction to only 4 categories that we refer to as FADO. The one at issue in this case is abuse of authority. A mistake with an internal NYPD procedure is not abuse of authority. The NYPD has its own disciplinary system, and both the NYPD and CCRB itself have recognized that body-worn camera errors are the NYPD's jurisdiction, not CCRB's.
Well, but the fact that that has been true in the past doesn't mean that CCRB is precluded from exerting jurisdiction over this category because of a change in circumstances or a change in viewpoint. That's happened before and been affirmed by this court, correct?
Your Honor, past practice is an important piece of evidence.
It's one piece of evidence, but it's not preclusive, correct?
It's not dispositive, but it's an important piece of evidence. And I'll submit, Your Honors, that the court's job today is to interpret the charter and specifically the phrase abuse of authority. And what did the City Council mean when they inserted the phrase abuse of authority as a limitation on the CCRB's jurisdiction?
Well, why not? Well, why can't we look at our case law? So, for example, in Lynch, we said that the definition of abuse of authority is the misuse of police power, correct? And let me finish.
Oh,
so isn't it fair to say that the failure, for example, under some circumstances to turn on a body cam or to turn it off prematurely is a misuse of police power under the Lynch line case?
No, the body-worn camera errors are not a misuse of police power, which this court in the prior Lynch case equated with abuse of authority. But our position is start with the statutory language. The Lynch case involved 2 very different types of misconduct at issue: sexual misconduct and intentional false testimony. And I think that's important because what you're dealing with in those cases, and again, we disputed the jurisdiction in those cases, but at least what you were dealing with in those cases was arguably more in line with traditional abuses of authority going back to 1993 when CCRB was created, which are things like unlawful stops, unlawful arrests, unlawful searches, an intentional violation of some independent right of a civilian. Sexual misconduct is an extension of that. Intentional false statements.
And then what about with mispronouncing the case, Giacomo, thank you, where we said that failure to provide a business card, even if not requested, falls within misuse of police power.
What that case dealt with was a violation of the Right to Know Act. So in that case, you're dealing with a statutory violation. So again, CCRB...
So what's the distinction between a statutory violation and the police guidelines? They both have to be followed.
Well, think about it this way. Why was CCRB created? What does CCRB stand for? The Civilian Complaint Review Board. So when you're dealing with a situation where an officer has a statutory obligation to provide a civilian with a business card, the civilian knows about that during the encounter. There's a statutory obligation. It's being violated. The civilian knows that their rights are being violated. they can file a complaint with CCRB. That's the whole reason that CCRB was created, to deal with these types of civilian complaints. When you're dealing with a body-worn camera error under the patrol guide, in most, if not every case, the civilian is not going to know whether or not there has been a body-worn camera error. So we're going far.
That doesn't mean that there isn't, that doesn't mean that the officer could not be acting intentionally, and that whether or not there's then body-worn camera evidence available could affect whether or not the civilian could realistically recover for an injury. For example, if there was a stop that was, or a frisk that was improper, and it turned out that before the officer began the improper frisk, he or she turned off their camera, then their decision to turn off the camera would deprive the civilian of an opportunity to prove what happened, correct?
That's a good question. I want to address that. I was just distinguishing the Di Giacomo case as at the end of the day, the court has to draw a line somewhere. Abuse of authority is a limitation on CCRB's jurisdiction. Our position is that this case goes too far. CCRB keeps going farther and farther. But to answer your question, and it's an important question because I think this is CCRB's main argument, and it's what the Supreme Court primarily relied on. Nobody's disputing that body-worn camera footage is important evidence in the investigation. And what CCRB is saying
it's more than a piece of investigation. It's also could be an element of the misconduct.
It's an element of the misconduct under the patrol guide procedures. And these types of patrol guide procedure violations have never been abuse of authority.
Let me just ask you a question. If an officer was engaging in physical violence towards a civilian, and before engaging in physical violence, turned off his or her camera intentionally, are you saying that that decision to intentionally turn off the camera could not be an abuse of authority?
It doesn't fall within the definition of abuse of authority. And so the way that situation is dealt with.
I'm sorry, why is that not an abuse of authority if the officer intentionally turned off their camera before engaging in some other improper act?
Because turning the camera on or off does not command the civilian to do anything. That's not the exercise of authority. And the way that that situation has been.
It's the same thing with giving over the information under the Right to Know Act. It doesn't command a civilian to do anything either.
Well, no, under the Right to Know Act, you're violating a statutory right of the civilian to have that business card. With the body-worn camera rules, this is a procedural requirement under the patrol guide. And the way it's been dealt with for years, and the way CCRB has dealt with it when it said these are not our jurisdiction, the underlying conduct of the police officer may fall within the definition of FADO. That gets investigated by CCRB. If CCRB uncovers an evidentiary issue like the body-worn camera violation, it refers that to the NYPD. That's the way it's been done. We're not saying that these things.
The fact that it's been done that way doesn't mean that it's the only appropriate way to do it. The question is whether their decision to include it now is arbitrary and capricious.
Not whether it's arbitrary and capricious.
Excuse me. And you keep going back to how it's been done in the past, but our jurisprudence is clear that they're not limited to doing things the way they've always done them.
Let me address 2 points that you just raised, Your Honor. In your example, there was an intentional act by the police officer to turn off the camera. Even if Your Honors think that that falls within the definition of abuse of authority, CCRB's rule needs to be stricken because it includes even good faith efforts by the police officer to comply with the body-worn camera requirements. If a rule by an agency is too broad, it's not the court's job to rewrite the rule. So I would ask, Your Honors, how do you deal with...
So let's look at that issue. So with respect to the issue of abuse, I mean, you define abuse as essentially it has to require an improper act. But aren't there definitions in various dictionaries that support a broader definition, including, for example, blacks, reasonable misuse?
Your Honor, the one dictionary that CCRB cited, which is from 1993, which I think actually makes sense because 1993 is the year that this language was added into the charter.
So we're frozen in time to 1993 to look at what the common use of the word was in 1993?
I'm relying on the evidence that CCRB put into the record, and the number one definition in the dictionary that they cited is a corrupt act or practice. So I ask you, How does a mistaken or an unintentional violation with an internal NYPD rule?
Why do you assume that that happens? Why do you assume that an unintentional you know, I was sick and I turned it off? Why do you assume that that's going anywhere under the CCRB new rule?
Because in CCRB's appellate brief, what they admitted is that ever since they've started handling these matters, 99.5% of the violations that they have found have incurred the lowest penalty, meaning these are unintentional violations. And when the NYPD objected to this rule, the NYPD said, in our experience as well, these are unintentional errors because these are complicated procedures. I mean, remember that police officers—
Right, but I'm saying, so at the end of the day, they don't go anywhere, right?
No, the CCRB will still impose the lowest form of discipline, such as it's called training or command discipline.
And that you're objecting to? Someone who doesn't understand what they have to do with respect to their body camera? You're objecting to the lowest form of, hey, get some training so that you do it correctly?
Your Honor, you're
You think
completely—
that that's arbitrary and capricious?
That's completely different than what we're saying. We're saying that the NYPD is the body that imposes that discipline, not
Is your issue, I'm trying to understand your issue. Is your issue that the CCRB is not trying to enforce the patrol guide and they don't have jurisdiction to do that, and or that there is no intent requirement?
I'm not sure I follow your question, but let me just say that as simply as I possibly can. CCRB does not have jurisdiction over body-worn camera errors, and this is an issue
Are
of
there
statutory—
areas in the patrol guide that CCRB does have jurisdiction over?
No, and I was going to say this before. So the best analogy here are written record-keeping requirements, like a failure by an officer to produce a report or a stop-and-frisk report or put something in his memo book. Even as we sit here today, CCRB admits that that's not abuse of authority. It's a record-keeping requirement under the patrol guide. Just like body-worn camera violations, one involves technology, one involves handwritten reports, but they're both internal NYPD patrol guide issues. They don't involve constitutional or statutory rights of the civilian. So at the end of the day, you have to draw the line somewhere.
So, counsel, are you saying that where this line should be drawn is where we're talking about internal patrol guide regulations?
That's correct, but I don't think you have to create a broad rule in this case. I think what you have to say in this case is that with respect to body-worn camera violations, which CCRB itself has admitted year after year are not FADO, that this goes too far and it's not in CCRB's jurisdiction.
Thank you, counsel. You may proceed.
Thank you, Your Honors. May it please the court, my name is Jameson Davies, the respondents. This court should affirm, as this court has twice held, CCRB is entitled to deference when determining what constitutes an abuse of authority under its authorizing statute. The CCRB's rule regulating body-worn cameras is issued after careful study and appropriate notice and comment.
Counsel, how do you handle the argument that this goes too far because now we're giving CCRB jurisdiction over what happens with regard to internal patrol guidelines?
Sure, Your Honor. A few things. One, the patrol guide covers a number of things that are within the CCRB's jurisdiction. The patrol guide deals with the proper use of force when you can stop and search a suspect. A lot of the things overlap. Not everything in the patrol guide is outside of the CCRB's jurisdiction. The only question is whether or not the conduct amounts to an abuse of authority. And to the point too, where he was saying that
So let me just make that clear, counsel. You are saying that there are parts of the patrol guide that are incorporated into CCRB oversight.
There are aspects. I think the patrol guide covers basically, as I understand, pretty much everything a
Right.
police officer does. So if he conducts, an improper stop and frisk that's in violation of the patrol guide's guidelines, that's also something that CCRB.
And it might also be in violation of law, but
Correct.
the CCRB has jurisdiction over it.
Correct, Your Honor.
So that it's not arbitrary and capricious to include more of the parts of the patrol guide.
Correct, Your Honor.
Okay.
And to the point where he was saying it's just really a paperwork error, things that have been defined as abuse of authority.
Yeah, that's what I think the question is. My question is, how do you deal with the argument every single time someone forgets to turn on their body camera, they're going to have a record of it, and now it's going to be used in subsequent, actions in court and in other ways?
Yeah, a couple of points, Your Honor. First, I think just to dispute the idea that the 99.5% number shows that those are all unintentional, that's not accurate. It doesn't mean that they were unintentional violations. It just means that the recommendation, that's the standard recommendation for a body-worn camera violation. It doesn't necessarily mean that all it means is that CCRB has concluded that there was a violation of the policy. And the officer has the opportunity, if it's truly unintentional, if the battery ran out, if it was knocked off by a suspect or something, that the CCRB is going to investigate, and it's going to find that is within guidelines under the CCRB's rules. So there's an opportunity, that's going to be a record of that investigation and a finding that it was within the guidelines if it was really a good faith error or a mistake, a technological failure, or something along those lines. And the CCRB has been doing that as it's been implementing these rules.
So I want you to talk about the plain meaning of the term abuse. Does it connote intentional acts only, or can it also include inadvertence, negligence, and the like?
I think it can include inadvertence and negligence or violations of the policy. It's as we define it, it's misuse. It's not necessarily an intent, and there are a lot of
what support do you have for this position?
Sure. One of the the dictionary definitions that you cited and that we cite in our brief. Two, there's already things that are undisputedly abuses of authority. They're in the command discipline matrix that we pointed to that are not intentional. Failing to provide language interpretation services that might not be intentional. Negligent failure to obtain a medical attention, that's by the definition of negligence, already unintentional. Failing to process a complaint, that could be unintentional. And so there are already things that fall within abuse of authority that are unintentional. And then finally, and I think most importantly, this court has already held it in DiGiacomo. Not only the rule itself, which was challenged, but there was an individual officer who challenged his own finding of a violation of the Right to Know Act in that case. And his argument was that the civilian never asked him to produce the card, and he was still cited with the violation, and this court held that that violation was sustained, even though it was alleged by him to be unintentional.
And what do you make of your adversaries distinguishing the case? I mean, essentially, there's a statutory violation of the civilian's rights, which is different, presumably, with the body cam.
I don't think there really is any basis for distinguishing between the statutory obligation and not. There are other, as I was talking about before, there are other...
Well, but more to his point, statutory violation affecting the civilian in that encounter, you would agree, it's not the same with the body cam. Civilian doesn't know if it's on, off, or what's happening with it.
I think two responses, Your Honor. One is, as Your Honor was pointing out earlier, I think it goes just fundamentally to the exercise of the officer's authority over the civilian. They're required in almost all instances to activate their cameras. It creates a record of what happened. And it not only failing to use body-worn cameras properly is its own abuse of authority, but it can facilitate other abuses of authority by depriving civilians of a record. And then secondly, I think it's just fundamentally different in the sense that a civilian could find out if they FOIA request the body cam records, they could eventually find out and file a complaint as well that if the body camera footage is unavailable.
Failing to turn on the body-worn camera is not exercising any authority over a civilian, though.
I think the fundamental just act of turning on or off the camera is not itself exercising authority, the same way failing to provide language interpretation services, failing to provide a business card in violation of the Right to Know Act, those are not directly exercises of authority over a civilian.
Well, language services is in a different realm because that's whether, in fact, the person can understand what's happening in the encounter.
Correct. Maybe that's not the best example, but failing to process a complaint is a better example. Maybe that a civilian brings in a complaint and the officer fails to process it. That's in the disciplinary matrix under abuse of authority, but not a direct exercise of authority over a civilian. And violations of the Right to Know Act, as this court upheld in DiGiacomo, as abuses of authority. Even if the civilian doesn't ask for the business card, it's still held to be an abuse of authority not to provide it. Unless this court has any other questions, I would urge affirmance. Thank you, Your Honors.
Counsel.
So I've heard the court mention the phrase arbitrary and capricious a couple of times, and I want to touch on that point because we're kind of starting on the wrong foot here, at least as far as we submit. This is not an issue of agency deference where you're just looking at whether the interpretation...
Except our holding in Lynch 2 and quoted in DiGiacomo a year later is that we defer to CCRB's interpretation of abuse of authority unless that definition is irrational, unreasonable, or inconsistent with the governing statute, and therefore that there's a heavy burden of showing the revised rules to be, quote, so lacking in reason that they were essentially arbitrary.
And the aspect of that holding I'd ask you to focus on is inconsistent with the governing language. That's what this case is all about.
It's also that they were so lacking in reason that they were essentially arbitrary. So arbitrariness is one way of looking at it.
There's two different standards. There's an arbitrariness standard, or is it inconsistent with the statute? And the Supreme Court of the United States just this summer also said what the New York Court of Appeals has said. When you're dealing with the jurisdiction of an agency, deference is least appropriate.
Are you suggesting this is governed by the recent Supreme Court case overturning Chevron?
The principles are equivalent.
Are you suggesting that we're governed by that in determining the standard for evaluating agency action in New York State?
Your Honor, I didn't say that you're bound by that case. I'm saying the principles are equivalent with what the New York Court of Appeals has said, that when you're dealing with the jurisdictional predicate of an agency, you don't give that agency deference. The New York Court of Appeals has said it. The U.S. Supreme Court has said it. And so let's look at what the City Council has said when it's talked about CCRB's jurisdiction, because I can make arguments, my adversary can make arguments. What has the City Council said? And we have 3 amendments to CCRB's jurisdiction in the last 5 years, which are very telling as to what abuse of authority means. And they confirm that this is a limitation. So on this issue about, well, these violations come up when CCRB is already investigating a fatal complaint, it's important evidence, and therefore CCRB should investigate it. The charter doesn't give CCRB jurisdiction over something just because it may come up during a fatal investigation. So in 2019, the City Council amended the charter to add false statements made by a police officer during CCRB's investigation of a fatal complaint. So if abuse of authority was as broad as CCRB is saying, CCRB could have just taken over that jurisdiction under the same arguments it's making today. Well, this is an officer acting against the interests of a civilian. It comes up during our investigation. It's important evidence. We want to take jurisdiction over it. No, abuse of authority has 30 years of established meaning, and when the City Council has wanted to change that, it's done it through charter amendments. In 2021...
They didn't take any action to overturn our ruling about the degree of deference we would accord to CCRB's rulings in terms of our decision in Lynch 2 and DiGiacomo, correct?
Well, it's not going to overturn a deference holding. I granted it didn't overturn the sexual misconduct and the intentional false statements, but those are very different than what we're dealing with today. In 2021, there was another charter amendment that specifically dealt with abuse of authority, and the City Council added racial profiling to abuse of authority. I ask you, if abuse of authority is so broad, why would you have needed a charter amendment in 2021 to add racial profiling? This is a term that had meaning in 1993. It's had meaning over the past 30 years. Things like improper stops, improper searches, body-worn camera errors, and unintentional violation of internal NYPD procedures. That's what CCRB is saying today. It goes too far. They're taking your Lynch decision. They're taking your DiGiacomo decision. They're saying abuse of authority is a catch-all. Now we can do whatever we want. There's no limits on abuse of authority. What would be the purpose of having FADO in the charter if it was meaningless? So this, again, this is a matter for the NYPD's jurisdiction. We're not saying that nobody can handle these disciplinary matters, but for the past, ever since the body-worn camera system started, the NYPD has been handling it. The NYPD objects to CCRB handling it, and we submit that the decision should be reversed. Thank you, Your Honors.
Thank you, Counsel. Thank you both. People versus White.
May it please the court, Matthew Bova for Mr. White. The indictment was facially insufficient because it failed to provide notice of the burglary charge. The indictment alleged in broad terms a trespass with intent to commit a crime in Grand Central Terminal. Now, the Court of Appeals in Sanger has confirmed that merely alleging the statutory subdivision at issue is not necessarily sufficient where, given the nature of the charge, the charging document does not provide notice of the crime charged. Here, any reasonable person receiving an indictment that says burglary of Grand Central Terminal would have absolutely no idea what they're actually being accused of trespassing into. Grand Central Terminal is a giant, sprawling complex. It has an endless number of private areas, an endless number of public areas. It has commercial areas. It has law enforcement areas. It has management areas. It has construction areas. This indictment required guesswork. Mr. White was entitled under the indictment rule, especially given the Court of Appeals decision in Sanger, that the statutory subdivision is insufficient. Under the indictment rules, he was entitled to more. What's particularly important here, too, is there was absolutely no reason for this rather unprecedented breadth in an indictment. The prosecution easily could have specified the allegation. Instead, the prosecution simply threw out a broad allegation and said, we're not required to provide
But
more.
why isn't it sufficient? It incorporates by reference the statute, and then it alleges that defendant entered the building unlawfully with the intent to commit a crime. Why is that not sufficient taken together?
Because burglary is a crime of location, and Grand Central Terminal contains an infinite number of locations that one can trespass into. So one would have to guess, what location am I actually accused of burglarizing?
In a location that's unlawful for people to be in.
Yes, but that doesn't
what's the
provide
guesswork?
But that doesn't provide notice. That just provides guesswork because there's
What's the guesswork in that?
Because, well, first of all, there's an infinite number of places where people are not, the general public is not allowed to be in. There's also many places in Grand Central, as Your Honor knows, that the public is allowed to be in. You have to guess, are they accusing me of being in one of those locations?
Why would you have to guess if they're accusing you of being in a public location?
Because the indictment rules don't necessarily assume that the prosecution's getting it right. But in any event, even if we assume that the prosecution is in fact alleging a trespass into a non-private location, we know that there's an infinite number of places within Grand Central where that could apply. We have all of the management and law enforcement areas. We have hundreds of commercial areas. Mr. White had no idea what he was being accused of. This is effectively the same thing as indicting someone for burglarizing a city block or perhaps an area of Central Park. And it's particularly important, it's particularly unreasonable here because there was no reason for it. The prosecution could have provided
A city
more.
block is not an enclosed building. It's not an enclosed place.
Well, if we assume for the purposes of a hypothetical that there was a city block that had one contiguous large building divided up into several apartment buildings, that's basically the same kind of notice. Well, you're accused of burglarizing one segment of a giant sprawling complex, and you should guess and figure out what it is. And reasonable notice means much more than that. The Iannone also provides an important contrast because in Iannone, there was actually specificity as to the usury allegations in that case, in the Court of Appeals' leading case. But the Court of Appeals made it also very clear in that case that a lack of notice was not alleged in that case. Here, though, there is a clear lack of notice because there was pure guesswork. Again, it's important that burglary, unlike, say, larceny, is a crime of location.
Counsel, do you want to talk about the waiver of right to appeal?
Well, so first of all, the waiver of the right to appeal would not cover the indictment's facially insufficient because that's a jurisdictional issue.
Because your time was running out, I was trying to move you forward.
So as to the waiver, the problem with the waiver, and this would really only apply to the suppression claim because the waiver could not apply to the jurisdictional issue, the problem with the waiver is conflation. What the court did was the court said, do you understand that as part of this plea you're waiving your right to a jury trial? And then immediately said, do you understand you're also waiving the right to challenge the suppression ruling? That conveyed to any reasonable person who's not well-versed in the nuances of appellate procedure that the suppression ruling was not an independently sacrificed claim by virtue of the appeal waiver, but that it was part and parcel of the plea itself. That's the kind of inflation that the Court of Appeals has said over and over again invalidates the waiver. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Nathan Morganti on behalf of the people.
Counsel, could you address counsel's argument that the indictment is unnecessary, is inappropriately vague because it doesn't say where in Grand Central the defendant engaged in unlawful activity?
Yes, Your Honor. There is no requirement that an indictment specifically specify where exactly in a building this burglary occurred. You know, for example, defendant's standard would require us to say it occurred on this floor of an office building or in this particular office, and that's just not what the Court of Appeals has said needs to be done to provide notice. Additionally, by providing defendant with the time that this incident allegedly occurred, as well as by specifying a singular building, it put him on enough notice to understand exactly what he was being charged with.
Well, but the claim also is that this is a building, which is a unique building, public access to parts of it, no access to other parts.
And, Your Honor, we would contend that actually that's not that unique of a building. There are a lot of buildings like that in New York, and the statute specifically contemplates that by having language in the definitions that talks about a person unlawfully being.
So you're saying it's sufficient to say that the defendant was unlawfully in Grand Central Station?
Yes, Your Honor. That sufficiently covers that, combined with, like I said, the time, gives defendant enough notice, and allows them to prepare defense, the two important factors that we look for when deciding.
Do you want to address the waiver issue?
Yes, Your Honor. Obviously, this court in Francisco did say that when you conflate the right to challenge a suppression decision by putting it in with trial rights, then that is an error. However, that's not what happened here. The trial court here asked is a separate question. Do you understand that you're giving up your right to contest a search and seizure? That's not what happened in Francisco. And then in the next question, the trial court went on to say the standard rights of appeal, that you would be giving up with a waiver to appeal. Additionally, there is a very strong waiver here, a waiver that is very similar to the waiver that this court and the Court of Appeals has approved of in Bryant and Brito. And that waiver explicitly said that part of the appellate waiver is the right to challenge any suppression decision made below. Additionally, defendant said 3 times, he was asked 3 times about his waiver of appeal, and he said he had enough time to discuss with counsel. So at worst, if this was confusing at all, there was an ample opportunity for counsel to clear that up and for the written waiver to clear that up. Very briefly, I know that my adversary did not speak about the merits of this issue, but this is well within what the court has found to be attenuated based on time. This court has found that as short as 45 minutes can lead to attenuation. This was 4 hours and 45 minutes. There were several intervening events. There was a new arrest in a different location by a different police officer from a different police force for a different crime. There was additionally...
How does the fact that Scott partook in the questioning, does that taint the attenuation?
I don't think it taints the attenuation, Your Honor, because what Scott did was his presence was minimal. He only asked about 11 questions, responded to 1 or 2 questions from the defendant just about what a day was. In contrast, the assistant district attorney who conducted the interview asked over 75 questions, counting statements designed to elicit a response to questions. Additionally, what investigator Scott talked about was cabined to be about a burglary at Penn Station, or a series of burglaries at Penn Station, which was not what defendant ended up being indicted for and eventually pled guilty to. Additionally, the assistant district attorney was very clear about separating those 2 incidents during this questioning. So any taint there would be minimal at best, and the fact that it was such a cabined discussion and cabined questioning means that there really would not be a taint from investigators.
Does the facts of this arrest without a warrant, which is shocking, does that somehow, how does that play into the analysis?
Your Honor, we are not contesting the decision that was below, that there was a patent violation. However, as discussed in Leroy M., this was not the kind of situation where the arrest was so and the violation was so flagrant that the taint can't be attenuated. And all of those intervening factors that we talk about in our brief, as well as the time, really shows how this was attenuated. And additionally, while this was a patent violation, the flagrancy was not as high as in other cases. There was an attempt at a consensual entry, there was a knocking on the door, which this court in Fishaw pointed to when saying that there wasn't that much flagrancy. And it's that shows that whatever happened at the Bronx did not taint the questioning that occurred almost 5 hours later in ECAP.
Thank you, counsel.
Thank you, Your Honor.
The prosecution's facial sufficiency theory has no limiting principle. As far as I could tell, the only argument is as long as you identify some structure on Earth, it is sufficient to allege that one has burglarized that structure, and then let the defendant figure it out later on at some point. That is not the law. The law requires reasonable notice. This is not an apartment building. I concede that you do not have to specify the particular room in an apartment building that is burglarized. This would be, Grand Central, though, is the largest apartment building on earth. It is a mega apartment building in terms of comparing it to the size of a standard apartment building. Obviously, it's not actually an apartment building, but the point is that it is giant compared to the standard apartment building. There are an endless number of theories of burglary that could be implicated by allegations this broad. There's no notice here. There is not necessarily a hard and fast, clear line between certain buildings. But we can clearly distinguish under the rule of notice between a typical apartment building, a typical office building, and a mega complex sprawling 20 to 30 acres with endless floors, endless tracks, and endless units. And as to the suppression claim, there was no attenuation because the flagrant violation of the Fourth Amendment rights infected the rest of the proceedings going forward because Mr. White was transferred throughout the process by that arresting officer who violated Payton. He was then involved in the interrogation. There was no sufficient attenuation, and the prosecution has not met its burden to prove attenuation.
Well, it was 4 hours, 45 minutes, right? The time between the arrest and the questioning?
Yes, Your Honor.
But haven't we found that to be sufficient time in prior cases?
Time is one factor, but it's not dispositive. And here we have the repeated involvement throughout the post-Payton violation process of an officer who violated Payton and participated in the interrogation.
Your adversary says, I think 11 questions were asked out of many, many questions.
Yeah, it's not, but the number of questions doesn't matter.
But aren't there other cases where we've said, I think there's one with 5 or 6, we said that was okay, correct?
Yes, but the issue here is it's not just the continued involvement of Scott, it's also, as Your Honor mentioned, the flagrancy of the violation. It is plowing into a room in a homeless shelter without a warrant, with no basis whatsoever.
Is that what happened? Did the officers plow into the room? Some issue of whether the door was open, not open, knocking, giving the person a chance to get together?
Well, whether it be plowed or not, the bottom line is the officer entered the home in violation of the Fourth Amendment without a warrant, and there was absolutely no explanation for that, and there were serious credibility problems with the officer's testimony about that entry, as the lower court found.
Thank you.
Thank you.
Smith versus Excel West.
May it please the court, Your Honors. My name is Scott Singer, and I represent the plaintiff appellant respondent in this case. As I pointed out in my reply brief, the decretal paragraphs of Supreme Court's order do not address plaintiff's claims in negligence or the doctrine of res ipsa loquitur. As a consequence, I did not include a specific point heading directed to negligence in my initial brief, although I did in my reply brief. Still, the body of Supreme Court's decision, which is quite confusing, contains statements about the plaintiff's negligence.
Well, that was a decision. What about the order?
Excuse me?
Isn't the order clear?
Well, you mean the decretal part?
Yes.
The
order. That's what we look at, right?
Well, yes, and the
So
decretal.
the order is clear.
It looks great, but another judge is going to look at this decision and says, well, you said there's no negligence or res ipsa loquitur, so you know, we're not going to recognize it. And that part of the court's opinion is incorrect.
But wouldn't it be fair to say that the reading of the order is that there has to be a trial on those issues?
Yes.
They weren't dismissed by the decretal.
It wasn't dismissed. Yes, I see that. But I mean.
So you want that clarified? Is that what
I think it should be clarified. Thank you, Judge Singh. Yes, I think it has to be clarified. There was very clear, I would dare say, overwhelming evidence of negligence in this case, as well as a clear res ipsa loquitur situation. But amazingly, it's ignored in the Supreme Court's decision, and it's also ignored in the report of their expert. They don't mention it. The fact is, there was a serious water damage situation, a flood that took place on April 19th, 2013. Everybody that examined it, everybody with authority and knowledge agreed.
But, I mean, didn't we just agree that that claim wasn't dismissed?
Well, as Judge Six said, I think it
right?
needs to
We
be.
all just agreed that in the decretal paragraph, that claim wasn't dismissed.
That's
All
absolutely
right,
true.
so
Justice.
maybe you should look at the 241 claim.
If you prefer, I do that, okay? So on the assumption that you'll clarify that misunderstanding. Yes, 241.6, the 23.1.7E, this court decided that it was a valid claim. There was nothing in the discovery that would indicate that the court's decision was wrong or affected, and as such.
Well, that was a motion to dismiss, and we didn't, there are two subsections to it.
Right.
Doesn't this appeal really address the two subsections?
Well, I mean, the two sections of E, 23.1.7E, there's a passageway and a working area.
Yeah.
Right?
Yeah, workway, right? There were two separate
Working
sections.
area, working area
Working
and
area.
passageway.
Right.
The working area, the law is very clear. If you need to go to a place, to get to another place that you need to do for the
So
work.
how is this a passageway?
That's a passageway because I would say it's a confined area that's functionally like a passageway.
Have we ever held that an elevator is a passageway?
No.
Okay,
no.
so let's
Well,
talk
well,
about
except,
let's
except,
do E2. Let's talk about the debris.
Except in the original decision here.
Well, that decision doesn't say anything about E1 or E2,
What, one or two?
right? It just says you've alleged enough for 241.6.
It was always debris in this elevator. It was used to carry garbage.
So that's and the Supreme Court kept that in, the E2.
They kept that in
Right,
correctly
because
because they said nothing has changed since the 3211 motion was decided.
Right.
As to 23.7.3, the court recognizes I have a serious problem with that because the court has ruled that that particular provision is general in nature. And I
Well,
acknowledge.
What? Toussaint speaks for itself. Right?
Toussaint is pretty clear, but of course, it was a 4-3 decision. It's not actually not that.
Toussaint was 3-2 here. I mean, so, but
3-2.
the law is the law.
It is what it is, right?
Look, it's a different kind of a situation. This is not, we're not dealing with the question of whether the person was competent or trained. There just wasn't a person there. What's general about that? That's very specific. There was not a person, there was supposed to be a person.
You have your debris claim, right?
Yeah.
And you're arguing now for something else for us to
I'd argue it, and I didn't, it was a recent decision. Nobody cited it before Supreme Court. Yes, the decision in Rivera, not Rivera, Estevez was, on its face, looks dispositive. I would say it should not be followed. Sometimes the court makes broad decisions, and they need to narrow it a bit. This is one of those. Thank you very much, Your Honors.
Thank you. Counsel?
Tom O'Connor for the defendants. With respect to the procedural question here in the decretal paragraph.
Just focus on your issues, okay?
Sir, sure, Your Honor. And so the court here was quite clear when it said the court finds that defendants have established its prima facie case that the elevator in question was not defective and did not malfunction. Thus, the doctrine of residence or loquitur is inapplicable.
Yeah, but the court below didn't dismiss the 200 or common law claims. That's for sure didn't happen.
Well, Your Honor, I would disagree with that based on.
So what in the decretal paragraph says, and the 200, that's where we're going on. So if you tell me that you see it, then that's something.
Your Honor, I
those
realize
weren't
that it's not perfectly clear, but from the body of the law, it's clear that there was no negligence found on the part of.
Well, so, and what the court was talking about is res ipsa in the context of a 241.6, which doesn't really match, right?
I don't think so, Your Honor. I think what the court was talking about was that this elevator in question, there is no evidence that it malfunctioned and that there's no evidence that this event even occurred. And so that throws that out. The question is, if it's not a...
Did you move, if you're saying there's an inconsistency between the body and the decretal, did you move to re-argue?
Well, Your Honor, I thought the decision based on my reading of this order shows that it's clearly in my favor.
When I read it, I just see the decretal. I look at the decretal because that's what we're bound by, right?
Well, I understand that, Your Honor, but the court...
Well, why don't we address your other claims?
Sure. The other claim, too, obviously, Estevez is knocked out. There's no concrete specification with respect to 7.3 and the need for an operator. With respect to passageway and work area, this court has always made the determination that it has always rejected attempts to broaden the definitions that are set down by the
So I think your
Commission of
adversary's
Labor.
point is that on the motion to dismiss, we left the issue there, I guess.
Your Honor, that was on a motion to dismiss.
But what about the E2, the debris in the work area? There's
This is
no
not-
doubt that there was debris, or that you may dispute the plaintiff's recitation of the events, but
Sure.
assuming that that is clear, there's debris on the floor of a work area.
Yes, Your Honor. If you look at this court.
That's E2.
No, it's not, Your Honor. If you look at this court's definitions, many people have tried to broaden the definition of work area to include areas outside of where people work and people actually conduct business. And for instance, there's a case that's cited in the brief, Your Honor, where the guy was in a shanty. There's other indications of people where this attempt to broaden this language to incorporate areas outside of actual work areas. This wasn't a
That
work.
was, I think the case you're citing, that was an open area? Wasn't that an open area?
It was not an open area, Your Honor. It was actually somebody moving a dolly through when they were doing.
So the statute says the parts of floors, platforms, and similar areas where people work or pass. There's no doubt that an elevator taking someone from one floor to another floor is a place where persons work or pass.
I would disagree, Your
Straight
Honor.
up. Show me where we have said that that is not.
Well, Your Honor, I would start with the first precedent, which is show me an area.
No, I'm
where-
asking you.
No, I'm going to do it. Well,
I'm asking you to point me to a case.
Your Honor. So if you look at that Chile opinion, where he was injured in a dolly in a storage area on a work site, this court refused to broaden the definition. Here, what you're asking for is a work area now becomes any elevator. And
Work or pass. E2 says work or pass, not just work.
No, but the definition is work area, Your Honor. It's not a question of whether it passes. The work area is a floor or platform or other area. It is not an elevator. And if the court takes this position to broaden it in this instance, where's the limitation on it? Is it elevators outside the building? Is it man lifts? Is it the commissioner was very clear in this language, and this court has never taken the position that it belongs to an elevator. And that's why the plaintiff has had to go outside of the language. The plaintiff has had to actually say, I'm going to go to 1.7D, and I'm going to say this is the functional equivalent of a stairway. And so what you're asking now is you're broadening the commissioner's language, and I think the way that's done, interpretations of statutes, don't apply in this instance. You cannot interpret the commissioner's language to be that broad. It wasn't his intent, and it wasn't in the language. Are there any further questions? And again, I would say that my last closing mark, Your Honor, would be, if you look at the Sinkyamani decision, which was decided by this court, this case is on all fours with Sinkyamani, down to the very fact that they have the same expert alleging the same type of factual evidence that's not in the record. The expert's opinion was incompetent, and it's all fours on Sinkyamani, and that's the precedent we should follow. Thank you.
Thank you.
I think the court doesn't want me to talk about negligence anymore, so I'm not going to do it. And as far as the 241-6 claims, I think they've been dealt with adequately. I just would like to point out, as the court is aware, because it's cited in my brief, ignored in the defendants, Rivera against Slade, Justice Rodriguez, you were on that decision, where the same expert made the same opinion. He concluded that it was a power outage, and the court said his opinion was speculative and rejected it and concluded that there was a question of fact as to negligence and res ipsa loquitur. So unless there are further questions, I'll rest on my brief.
Thank you both.
Thank you, Your Honor.
Your Honor, can I respond to that? Because I am an appellate
Well,
respondent.
you are an appellant, so I'll give you 2 minutes.
Sure. The Rivera versus Slade has no application to this case. If you look at the underlying facts of Rivera versus Slade, the man was trapped in the elevator. He was taken out by the fire department. There was a clear question of fact in that case about why the power went out. There was also a post-accident repair of rope grippers, which would have led to the accident. So when you go through Judge Bluth's decision, she took pains to make sure what the factual differences were. In this case, it's just like Cinco and Manani. This same expert, Carriger, offers opinions based on the facts that are not in the record. Here he offers 3 different factual scenarios, just as he did in Cinco and Manani. Here he says, If his first opinion is when the lights went out and the power was shut off, his first opinion is that two Kone mechanics must have done it on purpose, intentionally. I don't know who they are or where they came from. And then he comes back with his water opinion. And if you don't like his water opinion, he comes back with a dust opinion. So I would ask the court to look at Cinque Manani for this. Thank you.
Thank you. Thank you both.
Thank you.
Oliveira versus Topsail. You may proceed, counsel.
Good afternoon, Your Honors. Anthony Malecki for the appellant. There's one primary issue on this appeal, which is that evidence was submitted before the Supreme Court of two different versions of this accident. And despite what
But it's only evidence if it's not here. I mean, we can only treat it as evidence if it's not hearsay.
Correct.
And I didn't see any non-hearsay evidence from on behalf of your client.
I would say the incident report was a business record of our client.
But that doesn't make it, that doesn't go, first of all, there was no business record foundation laid. And second of all, there was no business duty established by the person who allegedly made the statement to the person recording the statement. So that doesn't get you very far.
The site safety manager testified in this case, and his deposition testimony testified as to one of his responsibilities is investigating incidents and preparing reports.
Right, but then the person from whom he learned the information that he put in the report no one established that that person had a business duty, and the statement that person made to him was hearsay.
But
so how do you get past that? If a person making an entry in a business record records something told to him which is hearsay, it doesn't get past it doesn't make it not hearsay because it's written down in a business record.
Well, I would point to the Buckley decision as being directly on point. The foreman who provided that statement to the site safety manager testified in this case that he was a foreman of the subcontractor that the plaintiff worked for.
And he also testified that he didn't say what was written in the incident report.
He said he didn't recall anything that he said.
He said he didn't say it.
He said he didn't recall.
He also said
asked
he
a
didn't
couple
witness the accident, and he said, and you're right, he said he has no recollection, but he also didn't witness the accident, so there's no personal knowledge there.
Great, but the site safety manager testified that the foreman informed him that the plaintiff told him how the accident happened. So he has personal knowledge from the plaintiff as to the accident occurring.
Well, that's not been established. That the foreman had personal knowledge from the plaintiff.
Because his sworn testimony was, if I give it to you, that he didn't remember what he was told.
Correct, but that's after he's provided a statement to the site safety manager and the written statement as well. So this is 2 years after the fact. His deposition
He also
is.
said he didn't remember providing that statement.
I'm sorry.
He also testified at his deposition that he didn't recall providing that statement.
He did testify at his deposition to giving a statement to someone from Related and telling them about how the accident occurred. I will concede that his testimony is all over the place in the deposition. He says, I don't remember secondary to every single answer to every single question. But he does make statements in that deposition that he gave statements to someone from Related.
But he never confirmed that the statement in question was a statement that he gave. Instead, his sworn testimony was that he didn't remember what he told them and he didn't remember what he was told about the accident. So how can we rely on that as evidence?
Because he gave the statement he said that he gave the statement to the site safety manager about how the accident happened, which then the incident report, because it has stated, says that it was obtained from the foreman, that's confirming that the foreman gave the information to the site safety manager confirms in that incident report, as well as his own testimony in this case, that he obtained that statement from the foreman. That's multiple levels of confirming information.
Multiple levels of hearsay, counsel, not multiple levels of evidence.
I disagree because this is all party statements. These are statements that the plaintiff told multiple different people at different times.
We don't know that he told that statement to the foreman. That's the problem.
Especially when he denied telling that statement.
I disagree that he denied telling that statement. I agree that he keeps saying, I don't remember it.
No, now I'm back to since we're in such a heavy weave of hearsay, I'm going back to what the plaintiff testified to. The plaintiff testified at his deposition that he didn't say what's in that statement that he said to someone else.
But does that not in itself create an issue of fact between the plaintiff, who is the only person who
No,
was
because
there?
the issue of fact has to be created on a fact and not multiple levels of hearsay.
But I still say that we have evidence here that the plaintiff told the foreman a different version of the accident.
What
It
is
was
the
then-
evidence of that in a non-hearsay form? That's the problem we have.
The foreman
You keep saying it's good evidence. I don't see where the non-hearsay evidence comes from.
I think it is the foreman's testimony that he provided a statement in support of the incident report.
Okay, so the statement that he doesn't remember providing is evidence of the statement.
Well, he both says that he provided a statement and that he doesn't remember providing.
No,
He
he
says both.
provided a statement, he just doesn't remember what the statement was.
Counsel, save it for redirect.
Yeah, certainly.
You may proceed.
Good afternoon, Your Honors. May it please the Court. Lisa Como for the plaintiff respondent. I think that it's very important, if we're going to talk about the incident report, to actually look at what it says on page 629 of the record. This is the gist of it. Worker says he was walking down steps from third floor to second and slipped down, hurting lower back. That's completely consistent with the plaintiff's testimony. That's been his position all along. He denied, as you noted, in his deposition, ever telling anyone anything different. Then it says, in the second sentence of the incident report, foreman says he was moving a washer machine for an apartment, something, he twisted his back. So foreman says, it's not attributed to anyone but the foreman, who admitted he was not a witness. So at best, what you have is some kind of hearsay statement that maybe came from the foreman without any indication at all of what the source of his knowledge was.
And a business record has to be made by someone with personal knowledge, right?
Exactly.
So
I
it's
mean-
not enough to say somebody else told me something.
Right.
Either I have to know it or that person has to know it.
Exactly.
And neither one of those are true here, right?
Right. I mean, it has to be, assuming it is a business record because it's created by Mr. McNamara in his course of business, then the foreman from a different company has to have, number one, a business duty to report to him, which hasn't even been established, I would submit. But even if
Well,
he did.
arguably, there would be a business duty, but,
Yeah,
but
let's-
that's not the issue.
No, but it may or may not be. There's some maybe, you know.
And there's nothing there to show how the foreman, whether or not the foreman has any personal knowledge, right?
Right.
So
he
we couldn't
clearly
assume from
disavowed
that
any personal
statement
knowledge.
that fulfills
Exactly.
4518.
The only way that they were seeking, they were trying to get it in, basically saying, if this said, and the foreman had signed it, acknowledged it, and he said, the plaintiff told me immediately after the accident occurred that it happened in some other way, that's a different case. But it's not this case. Clearly, the foreman has no personal knowledge. He denied any recollection to ever making a statement like this. And we also only assume the foreman means him because his name's not even on it. It does say Foreman Nick, but yeah.
May I interrupt you 1 second and just ask you something, follow-up?
Of course.
Was this produced, was Perales' statement produced in discovery?
Oh, the incident report or the other statement?
The other statement.
The other statement was not.
So that was never produced during discovery, but used in the summary judgment motion.
Right, and it was never even used at his deposition. I think the way we've laid out my reading of the case law on this subject, which is it's a little bit unusual. Basically, what they're trying to do with that unsigned statement is they're trying to use that out-of-court, unsigned statement that the witness, was never confronted with to prove the direct and main elements of a defense, let's say. But the problem is that even in the best case scenario, if Mr. Perselis takes the stand at trial and they were allowed to use that to cross-examine him to either maybe refresh his recollection or to impeach his credibility, if he said, no, I don't remember ever saying that, that would be the end of the inquiry. That closes the door. It's never can be evidence in chief. At best, all it could be used to cross-examine him. I would submit in this particular case, if they wanted to do that and they wanted to preserve their ability to do that, they should have done it at his deposition. Instead, they withheld it We had made a demand, the plaintiff's, counsel had made a demand for statements. It was never produced. It was never used at the deposition. They just held it for summary judgment, and I would submit it's like double or triple hearsay at that point. And even in the best case scenario, it would never be evidence in chief sufficient to create a question of fact under the cases that we've cited. I think that the lower court was correct with respect to the industrial code violations, with respect to the illumination, with respect to the debris. There's really nothing to contradict that. It's laid out in the brief, so unless the court has any other questions, I'd be happy to rest on my brief on those points. Thank you.
Thank you, counsel.
I will just finalize my point by pointing to 568 of the record, which is part of Mr. Purcell's deposition testimony. In responding to literally reading the incident report as to the washing machine, he's saying, whatever I told them, I told them. He's confirming that he told them something. I acknowledge, in addition to that answer, he's saying, I don't remember. But literally every single question on here almost, he says, I don't remember. So to me, his testimony, he at least has something in here that says, I confirmed that I gave you the information that was in that incident report.
When you read the part that he said, whatever I told you, what are the words surrounding that answer? I don't know, I don't know.
I don't remember, I do not recall nothing. Whatever I told them, I told them.
I do not recall nothing, right?
But in any event, how do you respond to your adversary's point that the information comes from nowhere? There's a statement with respect to what the plaintiff says happened, and then there's this other part of it. What's the reliability of that? We don't know who it's attributed to. It's not based on personal knowledge, obviously. Where does it come from?
Well, I mean, it comes from a conversation the foreman had with the plaintiff.
We have to assume that, though, right?
It doesn't say the plaintiff told me I was dragging a washing machine down the stairs or whatever, correct?
The foreman did not testify at his deposition.
No, I'm talking about the statement itself, the underlying statement.
The incident report or the statement that the
Statement in the incident report.
the statement in the, see, there's two different statements, that's why I'm asking.
Statement,
We've got these
the underlying statement.
The underlying, in the incident report. Or the longer two-page statement certainly says that the plaintiff came and told him about the accident.
I mean, when you say the longer two-page statement, are you referring to the one that was not notarized by Mr. Purcell's?
Correct.
So that one is of no value to us because it's not notarized.
Okay, but it's confirming the statement that's in
It
the incident
doesn't
report.
confirm something if we can't consider it. It doesn't get us anywhere.
Right. But the statement, I'm saying the statement in the incident report was confirmed by Mr. Perales at his deposition, and that says that he was told that the plaintiff had an accident in a different way.
Thank you. Thank you both.
Thank you.
Huns versus FH. You may proceed, counsel.
Thank you. May it please the court, my name is Naomi Weinstein. I represent FH in this appeal. The trial court order is completely an infringement on FH's bodily autonomy, as it subjects her to be forcibly treated with 5 medications that she has documented allergies to in her medical record and contraindications to, despite the clear, less restrictive alternatives that were already in place in this case that are not subject to this appeal, which is namely the PEG, the percutaneous endoscopic gastrostomy tube, and the 5 other psychiatric medications to which she has no objection to, including the 3 medications she was taking at the time of the hearing.
What are her objections to taking these medications?
So regarding the 5 medications that are subject to this appeal, 3 of them are documented allergies in her medical record, and not just in one part of the medical record, that a portion of which was entered into evidence at trial. It's throughout the medical record, including a nursing assessment, the medication administration records, and her individual service plan. Repeatedly states that she is allergic.
Is any of that in the record?
Yes, Your Honor. A portion of that record was entered into evidence.
There was one portion, but you're talking about other things that aren't in our record.
No, Your Honor. It is the portion of which the specific points of the record. So A58 is the nursing assessment record. The MARS, the medication administration record, is A73, 74, 71.
And part of that is she says, I'm allergic, right?
Respectfully, no, Your Honor. There's only one part of the
Okay,
record.
one part of the record says, I'm allergic to everything, right?
The rest of the record documents three specific medications that the hospital chose to record, which is the valproic acid, the haloperidol decanoate, and the flufenazine decanoate. And it's not just from her. There's no, despite.
Are they documenting that she said she was allergic to it, or that they medically determined that she was allergic to it? That's very different, isn't it?
Yes, Your Honor, and it's unclear. But the hospital, if they thought that for some reason these allergies weren't true, which is what they're now trying to allege in their appeal, then
Is there anything in the record that shows this, that shows there's a medical decision that she is allergic to those?
Yes, Your Honor.
What?
Yes, Your Honor.
Where does that occur?
The nursing assessment on A58, when she was first admitted to the medical record.
A15?
A58, Your Honor, documents the fact that she is allergic to these three specific medications, and the nursing assessment.
But isn't that information that is being reported to the nurses?
It's unclear. Correct, Your Honor, but it's unclear.
So I guess the question that we're asking is there any documentation, observations, when she's taken these medications that she had an allergic reaction to any of them?
Well, Your Honor, she hasn't taken the medications at issue because they're documented as allergies in her chart. And what was undisputed at trial
Wait. You saying that she hasn't been given these medications specifically because she's allergic to them?
It's unclear.
That's exactly what you just said. That is not true. Well, she hasn't been given them because she's been given other medication. That is, at this point, she's either not accepting or accepting, but they are able to give them to her. But in particular, one of the medications is a long-acting shot that would really help her out in a situation where she wouldn't, where she said, no, I won't take any medication, which she's done many times, right?
So, Your Honor, it's undisputed that we're not challenging 5 medications, and it is true that she is accepting them through her PEG tube. Regarding the long-acting injectable that Your Honor is referring to, the aripiprazole, the testimony from the hospital at first was that would be an alternative. It was only when the hospital counsel corrected that testimony that they said they would use it as an addition to the antipsychotic. What's undisputed here before this record is that she's clearly taking 3 medications: the olanzapine, which is an antipsychotic,
she's being given 3 medications. Let's be clear. She is refusing all medication.
So the testimony is that she's very clear, and what the doctor agreed to is that she's very clear about what she will and she will not take. And the testimony, undisputed, was that she's currently being given the olanzapine, the benzotrozine, the cogentin, and there's 2 additional medications to which are not subject to this appeal, to which she has no objection. The bottom line is that the hospital had to show by clear and convincing evidence that each medication, not just that she lacked capacity, but that each medication was necessary, that each medication, the benefits outweighed the risks. And here they just wholly failed to do so. And respondent admits to that by solely relying on things outside the record to support their position. It is undisputed, and I see my time is up if I can just briefly conclude, that the hospital did not even cover any of the alternative medications, that they did not do what Rivers requires, what due process requires in order to forcibly give someone medication, which is a medication by medication analysis to show that in her case, the specific medication is necessary, that the risks, that the benefits outweigh the risks, and that there are no less restrictive alternatives. Clearly, there were less restrictive alternatives here.
You're saying there was no testimony and no affidavits on at below saying that those, with respect to those medications?
There was no testimony about any of the alternative medications. If Your Honor is referring to an affirmation that was submitted as part of a motion for a stay, that is not properly before the court as part of this appeal.
No, I'm talking about the documents that were put before the court below. Is there an affidavit from the facility talking about, we need these medications? I mean, I've seen that affidavit, and that I've seen the affidavit. I know it's not a very complicated affidavit. It says, here's what we want to give. We've looked at all these medications. We think that, and it's signed by a doctor. You're saying that there's nothing in the record here?
No, Your Honor, because pleadings are not in evidence, and the case law is clear. Pleadings mark the boundaries of which, within the
Affidavit in
evidence.
support of the of the pleading is not here?
No, Your Honor, and if you're referring to the evaluation by Dr. Silberlicht, the hospital counsel could have admitted it into evidence, but they never did that, and they didn't call Dr. Silberlicht. So to rely on that evaluation or any sort of affidavit when she wasn't allowed to cross-examine that doctor, the doctor that testified that the hospital put forth did not meet their burden, and to rely on anything outside the record is wholly unfair and violates FH's due process rights.
Thank you. You may proceed, counsel.
Good afternoon, Your Honors. Joshua Cohen for petitioner respondent. May it please the court. Both parties here agree that FH is seriously ill and that drastic intervention was
I
needed.
want you to address, please, counsel's assertion that there is no evidence in the record that any of her treating doctors looked at these medications and testified either in the form of an affidavit or at the hearing that they had looked at whether or not the risks outweighed the benefits of these 5 medications that are on appeal.
It's in several places in the record, Your Honor, and in the
So
hearing.
let's say it. So
Yes.
that's gone unchallenged.
Okay. Well, Your Honor, Dr. Fan specifically testified at the hearing about the necessity for all of the primary medications, and he also explained that reasonable alternatives are needed in case of inefficacy or adverse effects and to account for patient preferences.
And at the
oral
hearing,
versus-
did he say that I have looked at whether or not the benefits outweigh the risks?
Yes, Your Honor.
All right.
He said that at page 41 of the record. And it's also just not true that that this court can't consider the sworn affidavit that incorporates a medical evaluation submitted by the doctor. The case that my FH cites for that proposition, Matter of Gale, is completely inapposite. That involves an order for assisted outpatient treatment under Mental Hygiene Law 960, also known as Kendra's Law, which requires specific in-person testimony, statutorily requires specific in-person testimony, and that requirement is not present here.
Are the medical records that are relied upon here about alleged allergies, are they attributed, are there tests or any background information, or are they notations in a chart that could have come from the patient who is stating that she's allergic to all medication right now?
The latter, Your Honor. There are notations in the record saying that she's allergic to specific medications, but as Dr.
Is there
Fan
any
testified,
background to that or underlying?
absolutely no evidence, and Dr. Fan testified that there's no evidence that she is actually allergic to these medications. As she asserts, and as her records say, she says she's allergic to all psychiatric medication, and Dr. Fan explained that that's a symptom of her illness, that there's no evidence of that.
Well,
And
there is some evidence of it, right? You can't say there's no evidence. There's a chart somewhere that says allergic to blah, 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 but we don't know the basis of that statement in the chart.
That's correct, Your Honor. And he also explained that the risks of her being actually allergic to these medications are reduced because, unlike most patients at Kirby, she is on one-to-one constant observation, and the hospital will be able to monitor her in real time and can take immediate intervention to change her treatment if it's ineffective or if she develops any adverse effects.
Is that because she's refusing food and
Yes.
nourishment? Is she still, even to this day, is she still on one-to-one?
Yes.
As far as you know?
As
Yeah.
far as I know, Your Honor, yes. And that's part of the unique circumstances here. We have to consider all of the circumstances. And part of FH's circumstances are the precarious nature of her medical condition. She's not eating, she's not drinking, she won't swallow her own saliva, she's given herself a cardiac arrhythmia and dangerously low blood pressure. If her condition does not improve, she's at serious risk of her heart stopping. That's the risk that we're balancing against the unsubstantiated risks of the challenged medication.
And was the doctor at the hearing confronted with those medical records that say, I'm allergic to this?
Yes, and
he explained and spoke about them at the hearing.
Yes, Your
And
Honor.
did the petitioner put in any other evidence herself about that?
No, Your Honor.
Just those records that he spoke about at the hearing?
Yes, Your Honor. And I will also add, if there are no more questions, thank you.
Go ahead.
Thank you, Your Honor. Regarding Dr. Phan's testimony, he did not go over the specific risks versus benefits for most of the medications. And in fact, he clearly didn't recall a lot of the record. When he was confronted with the allergies, he said, I don't recall, I don't know, if you say so. And he also stated that he didn't, basically he didn't believe what FH was saying, but he didn't take any efforts to, for example, consult with her outpatient psychiatrist who had been with her for 6 years. So again, I will refer also, counsel made the argument about her.
Do you dispute that portion of the doctor's testimony that the treatment was in her best interest? Because of really of a, as your adversary points out, an extraordinary poor prognosis. If I mean, she can die if she doesn't take this or eat.
Well, Your Honor, I would refer this court back to Rivers, which of course states that in a true emergency, if her life was at risk, the hospital could take whatever steps are necessary, including transferring her to a medical hospital, which had happened, to save her life. The testimony is,
I'm sorry, I don't mean to interrupt you. I just, following up on that, the doctor was confronted with the documents that you are discussing on appeal, right? And had the opportunity to testify as to why he didn't think those would prevent this medication. Other than cross-examining the doctor, did your client put in any other testimony or documents that would show that she should, under no circumstance, have these medications?
Our client did not affirmatively put in evidence, but it's not her burden.
And she didn't testify. I'm right, but I mean, the doctor did testify and so the court found that testimony credible and good.
But
that's why I asked counsel whether he was specifically confronted with the documents that you are talking about on appeal.
He was specifically confronted and he said, I don't recall.
And
so he was clearly.
The trial court found that to be satisfactory, correct?
Yes, but the trial court erred because they did not narrowly tailor the order to give substantive effect. And I would refer just as a final statement back to Rivers once again that states that it's the needs of FH's rights here that are paramount. It's the needs and desires of the individual and the requirements of the institution that are paramount, not the convenience of the hospital. Here there were clear, and there's a very specific, again, analysis that this court must take. And here there was very clearly least restrictive. There was no testimony that the current medication regimen she was on was not sufficient. There was an additional 2 medications that she could have been switched to if at any point the current medication regimen wasn't working. And therefore we asked this court to strike that part of the order that contains the 5 objectionable medications. Thank you.
Thank you very much. Thank you both. People versus Destiny S.
Good afternoon, Your Honors. The Legal Aid Society by Megan Teschler on behalf of Destiny S. By the age of 15, Destiny S., who is a verified victim of human trafficking, was abandoned by her mother, left to fend for herself in the streets, and coerced to work in the sex trade. In this exceptional—
You say abandoned by her mother. From what I understood in the record, she was going to high school. The high school, she didn't feel comfortable and she was coming home late, and so her mom told her not to come home late. And when she didn't, she changed the locks.
That's correct, Your Honor. But in this particular case where Destiny, who has a history of neglect and aggression from her mother, and she's a troubled high school student, and her mother doesn't nurture her, rather she changes the locks of the house and kicks a 15-year-old girl out of the house. I would say that
in terms of the conviction, you mentioned new legislation which would permit her to vacate her conviction. Why didn't you file for that?
I did not file for that for 2 reasons. It's something we are looking into after this appeal, and also I wanted to address the fines and surcharges, which are very important to my client, and in order to do so, we did this appeal first.
So in this instance, I'm sorry, go ahead.
In terms of the sentence reduction, given that what remains is a very small part, a very small duration of the conditional discharge, what are you seeking from us?
I am seeking to reduce the sentence to an unconditional discharge. And Your Honor, I know that it doesn't seem like an excessive sentence in this case, but
Well, when will the conditional discharge end?
it's my understanding that it will end November 6th of this year, Your Honor. And again, I know that it may not seem excessive, but every day the conditional discharge hangs over Destiny's head is a reminder of her status as a sex trafficking victim. This case, the criminal conduct in this case was born directly out of her victimization as a sex trafficking victim.
Well, she was also afforded youthful offender, right? So she doesn't have a criminal record.
That's correct, Your Honor, and I know that she does not have a criminal record, but again, she's stuck in this quicksand of trauma every day that the 3-year conditional discharge hangs over her head. And while that might not seem...
Wouldn't that be more of a powerful argument 2 years ago as opposed to 2 months left in the term? I mean,
I agree, Your Honor, but again, it's worth it to Destiny, and she has a right to ask this court to reduce her sentence. And again,
But you're admitting that it's not excessive.
Your Honor, I would argue that in Destiny's unique case, when she's trying to overcome this trauma, when she's a verified victim of human trafficking, and she's trying every day to distance herself from this lifestyle that she led as a young individual, I would argue that it is excessive every day that she's reminded of this case and this trauma. And again,
Conditional discharge simply means that she can't be rearrested on any other matters, because if she's rearrested, the case may be revived. Maybe, right?
correct, Your Honor. And once again, I understand it may not seem particularly excessive, but this young girl has suffered so much trauma as a result of her victimization, and this case is tied directly to that victimization. So,
and the trial court took all of that into account by, number one, encouraging her on the record, and number two, giving her an opportunity to obtain her GED and giving her youthful offender and adjourning the case so that she could have the time and the grace to do all of those things, correct?
that's correct, Your Honor, but once again, I would argue that, first of all, she worked extremely hard to earn her GED. It was not given to her. It was
the time was given to her, right? So adjourning the sentence so that she could have time to put that work in was given to her.
That's correct, Your Honor. She was given, I believe she accomplished it in 8 months. She was given a year. It was during the global pandemic, and as all of us know, during the global pandemic, it was very difficult to get anything done in the court system, let alone obtain your GED. And this young woman who faced...
If I could ask, I guess I'm confused by the following. If what you're arguing is that this conditional discharge is hanging over her head and it's continuing the trauma, I appreciate that. So why are you not asking us to end the conditional discharge?
I'm asking for a sentence of an unconditional discharge, which would effectively,
You could have asked for a reduction of the conditional discharge.
Your Honor, my understanding the difference is there are certain...
The difference is that if you ask to send the conditional discharge early, it's over.
I'm sorry, Your Honor?
It would be over.
I'm asking for a reduction in sentence to an unconditional discharge because she doesn't have...
All that does, it takes away the probability that she's violated if she's rearrested.
That's correct, Your Honor, but that's something that she is, and I know it's not in the record, but that's something that she is thinking about and that is hanging over her head.
Of course, that's something she has to be concerned about. She doesn't want to do that. But I guess, I don't know if you're appreciating my issue. Why don't you just ask us to reduce the conditional discharge to 2 years?
If the court is willing to do that.
No, I'm questioning, given your argument that this is hanging over her head, why didn't you ask for that?
My argument was that the unconditional discharge was just the disposition that I decided to request. I spoke with my client. That was the thing that we decided to do. And truly, Your Honor, it is the just hanging over her head, the trauma that she has suffered. An unconditional discharge would allow her to forget. And I agree with Your Honor, ending it at 2 years would allow, but so would an unconditional discharge. It would serve the same purpose, Your Honor, for my client. And in this particular case, where she is a very special type of defendant, she is a victim. She is a victim of extreme trauma in this case. So I would ask this court to reduce her sentence in the interest of justice. I see that my time is up unless this court has any more questions. Thank you very much.
Thank you.
Good afternoon, Your Honors, and may it please the court, Juliana Susu for the people. The defendant's sentence of 3 years conditional discharge is fair and lenient and should not be disturbed on appeal.
What purpose of the criminal justice system would be disserved by our reducing this to either an unconditional discharge or to a 2-year conditional discharge? Is there any purpose of the criminal justice system that would be undermined by our doing that?
By reducing it to unconditional discharge,
Or to reducing it to 2 years of conditional discharge?
no disservice would be done to the defendant, but for the criminal justice system, the seriousness of the defendant's conduct.
But wait a minute, wait a minute. We're talking about a woman, a young woman who was trafficked. We're not talking about a crime on the subway. So this is a very, very special circumstance, at least in my view.
Yes, absolutely. And the sentencing court was well aware of the defendant's circumstances as they were detailed.
So then answer my colleague's question with that in light. You're dealing with a woman who was trafficked from a young age. What service does it do to the criminal justice system to reduce it at the very least? How is the criminal justice system hurt as a result of that?
Well, the criminal justice system still has to take in consideration the seriousness of the defendant's offense. It can't go unpunished for what she did. And
Well, if we reduced it to 2-year conditional discharge, she would have still been punished by 2 years of conditional discharge. You're still not telling us how that would harm or undermine the purposes of the criminal justice system if we were to reduce it in that way.
the 3 years of conditional discharge as opposed to 2. One, the 3 years was mandated because she pled guilty to a felony. So it had to be 3 years conditional discharge. But the sentencing court had to take into consideration not just the defendant's personal circumstances, but as well as the seriousness of the offense. The defendant, yes, the defendant stole nearly $12,000 in cash and valuables from the victim. And the sentencing
No one was injured, right?
These are victims that were harming her, right?
I'm sorry?
These are victims that were harming her, correct?
I think that can be suggested, but that wasn't particularly determined. I think the sentencing court was aware of that.
You're saying it's not her pimp?
I'm sorry?
You're saying it's not her pimp? Who did she steal from?
I'm sorry?
Who did she steal from?
The victim.
Right, who was the victim?
To her.
To her, I think
A person she had a business relationship with?
No, I don't believe so. It was someone that she met that night. From all we know, from based on the record on
It was a John.
No, all we know from the record is that she was at a bar.
Yeah, she was at a bar. She
We
went
don't
to the
have any
hotel.
indication as to whether, in fact, at the time she was arrested, she was engaging in any sort of prostitution.
Exactly. All we know is that the defendant stole the victim's Rolex watch that was around $6,000 and the victim's wallet, which contained $5,900 and his ID. She was charged with 3 felony charges, and one of them being third-degree grand larceny, which alone carried a prison sentence of a maximum 2 1/3 to 7 years in
I
prison.
just want to ask you, so you're saying the 3-year conditional discharge was the minimum that she could have gotten under the plea that she pled to?
For pleading to a felony, yes. For pleading to a misdemeanor, it would have been 1 year.
Right, but she pled to a felony,
Yeah, she
right?
pled to a felony.
And in addition to that, her plea to the felony here covered another potential felony she had in another part.
Exactly. She had an open pending case that involved very similar conduct dismissed as part of her favorable plea.
And assuming that next month nothing happens, she'll get a YO, this will go away, and this record will be sealed.
Exactly.
correct?
As part of
So she'll get the same relief next month that council's asking for right
exactly.
now.
The
Okay.
conditional discharge just asked her to live a law-abiding life. She's shown that she can do that, and she can continue to do it for the 2 months left.
And would a 3-year unconditional discharge been a legal sentence at that time?
Unconditional discharge would have, yes, that would have been permissible, but it would not have been appropriate here. If there are no further questions, we ask that you affirm. Thank you.
Your Honors, I would just like to briefly address the seriousness of my client's conduct. Well, she's not denying that her conduct was serious. The alleged complainant, I believe it was in the People's Statement disclosure, it is alleged that the complainant, I believe, is a client of hers, and she was engaged in sex work during the pendency of this case. In addition,
Her other case in the F part, that involved another client as well?
Your Honor, I don't believe the facts of that particular case were before this sentencing court because it was in a different court part, so I don't
Well,
believe...
it covered, right? So when she took the plea, the information that I saw in the record was that her pleading to this particular case would cover that other case.
That's correct, Your Honor, and I'm not disputing that. I am only saying I don't believe that the facts of that particular case were before the sentencing court, so I don't believe that it's appropriate for the court to consider the facts of that particular case. I understand.
I wasn't considering it. I was just asking you whether, in fact, it involved the client, since you said her criminal conduct all centered around her being trafficked.
Your Honor, again, I don't want to speak to that particular instance because, in fact, it wasn't before the sentencing court, those particular facts. So I'm not going to get into whether or not that conduct was a result of her work in the sex trade. I can't say that I imagine it was.
Do you agree that the only options we have is an unconditional discharge because she pled to a felony, so we can't reduce it to 2 years?
That's
correct?
right. I believe that's correct, Your Honor. She needs to serve either a 3-year conditional discharge or an unconditional discharge, and that's why I'm asking for the unconditional discharge because she, again, I understand that a 3-year conditional discharge may not seem particularly onerous, but Destiny does suffer with this every day. And as to the seriousness, it's my understanding that the complainant received the property back. There was no violence alleged in this case. And she took responsibility for this case when she completed her GED within the time allotted by the sentencing court. So she's rehabilitated and she's educated and she's left her traumatic, she deserves to leave her traumatic past behind her. Thank you.
Thanks very much.